Okay, let's continue.
Thank you, Chair. May we give you an update on the solution to the problem about missing annexes?
Yes.
The Secretariat has very helpfully sorted out the problem
Okay.
by copying the missing annexes and slotting them into my file and that of the witness. And we've taken a liberty after first checking with the Chair's associate.
Yes.
To uplift your file, Chair, and all of those annexes have now been slotted in their appropriate places.
Okay.
So it is now comprehensive, and we must thank the Secretariat for fixing up the problem that arose yesterday.
Yes.
We apologize to you, Chair, for the difficulties.
No, that's fine. That's fine. Thank you.
Mr. van den Heever, let's deal, if we may, with the last few sections of this particular contract. That's the platform hulls contract procurement. You've already taken us to the. You already explained what happened and why at the sessions, the feedback sessions, and then your affidavit refers to a further request that was then made by DLS to revise prices, revise their proposals. You indicate in your affidavit based on issues raised during the meetings. Now, can you tell us what that relates
to? Which page are we on now?
On page 103. That's your affidavit.
Yeah, okay, the changes that we requested was according to the clarification questions we had, like for instance, LMT did not include paint in their price that they quoted, so they had to add the painting cost to the quotation. But there was various, like according to the questions that we asked that we needed clarity on, they had to amend the quotation that they sent to us with the new information and then resend it.
And then on page 104, most of that page is devoted to the information contained in the revised proposals of 27 June 2014 can be summarized as follows. That's a reference to their response to your request for further revised proposals.
That's correct, yes.
As I understand it, LMT tried to explain its pricing. Did they actually make any change to the pricing?
Yes, their price changed from 736,534 to 763,191. That was due to the paint included.
Right. And then DCD made no changes.
Yeah, they just confirmed, I think it was a bond, raising a bond, performance bond, the cost of
and
that.
VR Laser sent in a response, but they did not revise their pricing either.
That's correct, yes.
Okay. Now, you then deal, page 105, with the evaluation sheets and the bid scoring. May I just check, were you part of the process? Were you involved in the process of actually scoring the bids in question?
Yes, I was part of the bid BEC that did the scoring, but I was not involved in the final consolidation of everything.
Just explain to us, please, why you were involved in part but not the final part. What actually happened?
I cannot give you the reason, but after the BEC did the evaluations and the scorings and stuff, all the documentation was collected and then taken by Roland Rakadoe, and I don't know who helped him or who was involved in it, but they did the final reconciliation and consolidation and everything, and then I just received the final results.
So you what? Just repeat the last bit clearly.
I just received the final results at the end.
Right, thank you. Did they change any of the scoring that you had agreed to in the bid evaluation committee when they did that process?
Not that I'm aware of. Anything.
Not to your knowledge, right. If I can please take you to page 132.39. And just to explain for the record, the reason why the point 39 appears is that this is a document that was missing earlier and has now been inserted as it should. So in order not to disturb the overall pagination, that's why it's been done, Chair.
Just the page again, 132?
132.39.
On there.
Now, admittedly, we saw the same document in a different annexure to Mr. Drevin's affidavit earlier when he gave evidence, but, and as the Chair pointed out, there too, as here, I'm afraid, Chair, the photocopying has meant that it's very small letters printing. But can you confirm, is that your name and your name and your signature with the date 27 June 2014?
That's correct, yes.
And what is this document? At least we can read consolidated evaluation sheet. What does it tell us?
This one is where they,
I'm
the
sorry, Mr.
consolidation.
Kennedy. I'm sorry. Is this the one that's supposed to be better?
Supposed to be?
Is this the one that is supposed to be better? This is the one which is supposed to be legible.
No, we're not suggesting that.
Oh.
As I was saying earlier, it's got the same problem as the one we looked at earlier for Mr. Drevin.
Yes.
So that hasn't been done yet.
Or we haven't got a larger one or a clearer copy.
Not yet. So far, we've only achieved a resolution to the one problem, is that it is present. It is now not absent.
Okay.
But now we need a
Right,
bigger copy.
then I'm relieved because I was thinking if this is the better copy, then
I'm sorry to disappoint you. It was the first problem, not the second, that we've thus far been able to remedy with the assistance of the Secretariat. Thank you.
Okay, all right.
But does this reflect the scoring that was done in the evaluation of the bids?
That's correct, yes.
Okay. Then to go back to your affidavit, because there at least the font is big and the copying is clear, you deal with the evaluation back at page 105, paragraph 65. You refer to the split, the price points for technical and triple BEE, the percentage for each of those, and then you refer to how there was discussion within your committee about how the weighting would be dealt with. Is that right?
That's correct, yes.
And there was agreement by the committee as to how the scoring would be done.
That's correct.
Then you deal at page 106 with a topic we need to spend a few minutes on, and that's the triple BEE requirement. Now, at page 106, you mentioned that there was a problem that was due to an error on your part. You didn't include a requirement in the original invitation. Tell the Chair, please, what did you erroneously omit?
Okay, when I sent out the RFQ, I did not request each supplier to submit a BE certificate or a valid BE certificate, but that was requested during our verification session that we had with each supplier, and we asked them to submit BE certificates for us.
Now you refer there to this is apparent in the RFQ invitation. You refer to the annexure number HVD 28, and now fortunately it has been now located and put in the bundle. If I can ask you to turn please to page 132.102.
Okay, I'm there.
In fact, the first document's at the previous page, 132.101. That's the update request. And then 132.102, is that the original request for offer?
That's correct, yes.
Now, is this the document where you should have put in a request for a triple BEE certificate?
That's correct, yes.
And you say that was omitted. Why was that? How did that come about?
during that stage, it was almost standard for a supplier to submit a BE certificate and a tax certificate with the quotations that they submit to us. And I just forgot to request that, or put it in the request.
Right. But the certificate was important, was it?
Well, that was a standard. I couldn't place any orders without BE certificate and a tax certificate, tax clearance certificate.
Right. Now, then to go back, did you then request suppliers to submit their triple BEE certificates?
That's it. During that clarification meeting we had with each supplier on the 26th of June.
The feedback, the clarification meetings that you held separately with the three.
That's correct.
On
Each
that
supplier was asked to submit the BE cert.
Right. Did they then supply them?
Yes. I think they were given 14 days to submit, if I could remember correctly.
Right. If I can take you please to I'm sorry, Chair, if I can just have a moment, if you'd indulge me. Right. Now, you refer in your affidavit to the expiry of LMT certificate. Just explain what in fact was there a problem and why?
We were in June 2014 at that stage, and the expiry date on their certificate was 20 May 2014, which was just over a month expired.
If I can take you please to page 132.113.
There.
And what is that?
132?
132.113.
Okay.
Okay, that is a letter received from Empower Logic stating that LMT is in the process to do their BE verification, and that it will be done within 4 to 6 weeks. It will take 4 to 6 weeks to complete.
So this letter refers to Empower Logic having been engaged by LMT to perform their triple BEE verification, and they indicate that that process was still underway, but the verification would take another 4 to 6 weeks.
That's correct.
Did you in the BEC or did anybody else give a score to LMT in relation to triple BEE?
No, that was not part of the scoring process done by the group.
Right.
That information was done on the next level where Mr. Rakudue collected all the documentation and did the finalization.
Right. Thank you. Let's move, if we may, for a moment to page 109 of your affidavit.
On there.
You refer to a consolidated evaluation sheet, and that you refer to as being Annexure HVD 031. Just turn for a moment to page 134.
Yeah,
Is that the evaluation sheet that you're referring to?
that's correct, yes.
Here, I must point out to the chair, although it'll be perfectly obvious to him, that I'm afraid the print is even smaller here, and that will be remedied too.
I'm still trying to get there. Did you say 134?
134, Chair, yes.
Okay, let me just get there. You know, when you see 132, you can think you are close to 134 because of...
Logic is changing,
so
Chair.
you find yourself traveling a long distance before you get to 134. Yes, I've got 134.
Can I just say that at that stage I received a whole file with all the evaluations and final scorings and consolidations in one file, given to me in my office, telling me there's the results, the order for VR Laser is the winning bidder, and we're going to place the order on VR Laser.
Yeah. And the way in which it was done, when you were just presented with that as a result, did you find that normal? Did you find that acceptable in terms of process, or did you find it unusual and disturbing?
Well, as mentioned in my affidavit, is that we've never done this or the scoring, and I wasn't sure how it worked and where the percentages and stuff came from. So I had no background on it, no training. The whole team had no training. It was a first for all, so I couldn't find any fault in what was happening.
Right, thank you. Now, although at that page we've just looked at, the print is very small, you've helpfully, in clear print in your affidavit on page 109, set out the important features. And here you refer to VR Laser receiving the highest score, received a total of 65.54%, and then you give the breakdown, 10.39% for price, 50.15% for functionality or technical, and 5% for triple BEE. And you've referred here to the price of VR Laser in 81.1 of being 262,406,000, etc.
That's correct.
Which is of the same order as the previously submitted quote, correct?
That's correct.
Then you refer to LMT coming second. It received an overall score of 64.78%. That's very slightly less, in fact less than 1%. It's 0.76% less than the VR Laser score in percentage terms. Is that correct?
That's correct.
And their financial offer was 165,612,000 and the odd rand. So still there was a difference of not quite, but almost 100 million rand between LMT and VR Laser.
That's correct.
And then DCD came third. Their price was still over 300 million. Correct?
That's correct, yes.
Now then you refer to your preparing a submission to EXCO to be reviewed and signed off by Ms. Malashlela. Now if I can ask you please in the bundle to go to the document, page 136.
There.
That appears to be an email from you to Ms. Malashlela saying, hope I've captured most of the points required this morning. And was there attached to that email the document that then follows at 137?
That's correct,
and
yes.
Following. And what is this document?
That's the Chief Executive Supply Chain Submission requesting the approval of the order.
Right. And so we see at page 141, paragraph 7, a recommendation. Correct?
Yes.
Now, this is what you said. You prepared this document, is that right?
As you can see from my mail that I've sent to Celia, where I said, I hope I've captured most of the points required this morning. She basically told me what to put in the document.
Okay. Now, what the document says in 7 is the following. The following is hereby recommended, 711, that a contract can be negotiated and an order placed on VR laser services for phase 2, presumably, of the Hoefyster contract with a total value of 262 million and some thousands of rands. That is the price that had been tendered in terms of the further revised proposal received from VR Laser, correct?
That's correct, yes.
Right. But then the document continues, 712, this is a ceiling amount, as further negotiations with VR Laser Services will take place to obtain a price below DLS budget. Now, you referred us earlier in your evidence to VLS having a budget. What was that budget amount?
I remember correctly, it was, I think, 206 million or 209 million, I'm not sure.
And what was here being recommended was a contract to be placed on VR Laser for a value of 262 million, which clearly is considerably above the maximum, the budget maximum amount that's available.
Yeah, well, I was, if I can't remember correctly, but this was I was told by Celia to put this in with the negotiations, putting in the ceiling amount for further negotiations. I think she said there was some sort of a mandate that we had for 1,050,000 or 1 million or 1,050,000 per vehicle that we need to negotiate. So that's, I think that's why this was put in.
Yes. So this point about it's going to be for 262 million, but that's the ceiling amount. It would be subject to negotiation to try and bring that down, bring it within the budget maximum.
That's correct, yes.
Yeah. And
what did it mean to say it was going to be a ceiling amount? It didn't mean that there would be negotiations to try and bring it VR Laser down on the price, but if there was if they didn't agree, then that would stay as the price. The ceiling amount would remain as the price.
Well, that's basically what it's saying.
Yes.
But yeah, that's a ceiling amount. It won't go above that.
Yeah.
It could stay the same.
Yes.
But
the
idea was to negotiate it down, yeah.
But what does this reference to a ceiling amount add to the meaning of this thing? Because if there's an agreement that your price is 262 million, obviously that can't be increased without agreement. So what is this whole thing about saying it's a ceiling amount? Which is just to mislead people to think there is some value, it won't increase. So they must find comfort in that.
Yeah, it basically comes down to you can approve this, it won't go higher than that, but it can go lower. So yeah. That's what it's basically saying, yeah.
Okay, all right. But what it represented is they accepted this price, but just said we'll try and negotiate them down. But obviously, if they don't agree to go down, this will remain as the price.
Yeah, at this stage,
it
was on management level for their decision on what should happen and what the plans will be.
Okay.
Thank you, Chair. And just arising from those questions, Mr. Van den Heever, if VR Laser was approached to negotiate a reduction below the 262 million, and they wouldn't agree to any reduction, it would stay at 262, you've said that to the Chair, but then that would still be above the budget
Right.
What would the result of that be? That they would get the contract for 262 even though you were way exceeding your budget, or that the contract would not be awarded to them? What was your understanding?
Well, if you look at the document, if they approve that amount of 262, you've got the mandate to go and place the order for that, but you still need to prove that you try to negotiate the price down.
Right, and then if I can take you at page 137, the first page of this document, it's addressed to EXCO. Would that be EXCO of
DLS.
DLS, not head office?
That's correct.
Not the group EXCO.
That's correct, yes.
Right. This does not indicate, unless I've missed it, anything as to who should approve it outside DLS. If I can take you to page 142, there's provision for various signatures.
Yeah, you see, the process that we normally follow, there is a DLS supply chain committee that we take this to them. They sort of approve or recommend it, and then it goes to EXCO. Then once EXCO sees it and recommends it, then to DCO. That's the process that we follow.
Right. So this was simply for the first, it was for the approval within
DLS.
DLS, and if was approval required outside DLS, in other words, at head office level,
That's
as far as
correct.
you were aware?
That's correct, yeah.
Okay. And that would then be dealt with in a separate document, presumably?
That's it, yeah.
Right. You weren't involved in the preparation of any document for that?
No.
Do you-
That gets done on EXCO level.
Right. Now, Mr. van den Heever, you refer in your affidavit to disciplinary proceedings happening against you. If I can take you back to 110.
That's correct.
But as I understand your affidavit, that does not relate to the procurement process of scoring and awarding the contract to VR Laser, or does it?
No, but it was during that process, with the communication with the suppliers, that I made LMT aware that there was other suppliers also in the running for the contract.
And were you disciplined for alerting VR Laser, alerting LMT to the fact that VR Laser was also bidding for this contract?
That's correct, yes.
And it appears that you were suspended, is that right?
That's correct.
And subjected to a disciplinary hearing that lasted 5 weeks.
That's correct.
And you don't say whether you were found guilty or not guilty, but a sanction was imposed, so I assume that you were found guilty.
Yeah, and a final written warning was given.
Yes. All right. Now, finally, in your affidavit, I'd like to take you to page 111. Purchase orders issued to VR Laser, and here we come to paragraph 93. Now, here we, as mentioned earlier, but we didn't go into a full detail of it. I mentioned earlier to the Chair that you have, at the request of the team, updated certain figures, and you have prepared a supplementary statement. That's the one that I mentioned earlier, Chair, that is, with your approval that you indicated earlier, to be filed as Exhibit 14,
W
W14.1.
14.3.
Oh, point 3, I beg your pardon,
Yes.
correct. Chair, again, we've had some logistical constraints, but with your leave, may I hand up the signed supplementary statement as indicated to you earlier, Chair?
Yes.
This has not yet been attested, but that will be attended to.
Yes, okay, that's
Okay.
fine.
May I, with your leave, then hand up to you, Chair, subject to the arrangements that will be put in your file in due course, properly marked, and then replaced by the
Yeah, that's
affidavit.
fine.
I'm
Thank
afraid
you.
we have not had enough copies for everybody to be made.
Oh.
So I think perhaps, unfortunately, the witness doesn't have the supplementary statement in front of him. Perhaps my copy should just be made available with your leave. And I would just put a few questions to Mr. van den Heever as to what the effect of the amendment is. May I?
Well,
Thank you.
it looks like maybe today is one of those days. When there's always going to be something that goes wrong somewhere. Well, it is signed by him, but not by the Commissioner of Oaths.
That's right. There was apparently a logistical problem on his side
Yes.
yesterday.
Yes, no,
But-
that's
but-
fine. I'm sure it will be fixed. I was just saying, sometimes just everything goes wrong.
I'm afraid this particular body of the evidence has had all these hiccups, but we've
Yeah.
hopefully been able to get to the end of it
Okay, no, that's fine.
with that sorted. So we
Yeah.
apologize for all these issues, Chair.
Okay, are you going to be asking him questions on that one now?
Just if I may ask the witness to explain why it was done and what was
Yes.
done and what the outcome of it is.
Okay.
Mr. van den Heever, would you help us with that? You indicated earlier to the Chair that you were requested by my colleague, Ms. Sabia, to update the figures. Is that correct?
That's correct,
That
yes.
And those are the figures that appear in your paragraph 93. Now, what do the figures show? This is a spreadsheet that you've now given the updated spreadsheet, correct?
That's it.
And what does it show? Does this reflect payments or value of purchase orders?
Yeah, it's the value of orders placed by me on VR Laser for a period from August 2008 to the requested date of 31 March 2014, with the reasoning that that was when VR Laser ownership changed to Gupta ownership.
All right, thank you. Then to return to your affidavit that we've been looking at, 111, page 111, paragraph 94 says you confirm from the period 12 August 2009 until the signature of the Memorandum of Agreement with VR Laser Services in 2015, I issued purchase orders to the value of 232,959,000, etc., on VR Laser.
That's correct.
Right. Now, does that relate to the orders placed under the hull contract?
That's whole contract, everything. All armor plate work that DL is required, that was placed on VR Laser by me, comes to that value for that period.
Right.
I'm not sure. I think, yeah, the whole price could be included in. No, the whole prices was not included in this, I think. I can't remember, but we'll have to have a look on the spreadsheet.
Okay. And then at page 112, you refer to the fact that is common cause that all the other witnesses have confirmed, that there has been a memorandum of agreement signed between VR Laser and DLS on the 16th of April. That was where VR Laser was appointed as DLS's single source supplier of all fabricated steel services and goods. And were you involved in the procurement for that contract?
Which contract are you referring to
The
here?
single source supply for
No.
DL, not
Was
that.
Not involved in that at all.
Right, so your affidavit doesn't deal with that process, but your affidavit does deal with the rest of this page 112 for certain figures that relate to payments. Or, sorry, not payments, but the total value of orders in 97, 102 to 112.8 million rand. Now that relates to the single source supply contract, does it?
That's it, yes.
Okay, thank you. And then you refer to the outstanding order lines at the time was closed. There was a directive that all outstanding order lines be closed. Why was that issued, do you know?
The directive that was issued by the Denel SOC stated that all business relationships with VR lasers be severed on 1 June 2018. And that was due, well, when the state capture or investigation started, all work with VR laser was ended.
Now, so what does the 56.1 million represent? Is that orders that had been placed that were then put on hold?
Yeah, what I'm saying, that 56 million, okay, the previous one, 112 million, was the amount that was placed based on the MOA.
Yes.
And then after the directive, the open lines was closed, which is telling us that 56 million of that 112 million was already delivered and completed.
Right. And then you explain that in the next paragraph. Right, thank you. All right, thank you. May I just have a moment to confer with my team, Chair?
Yes.
Sorry, Chair, may I just... May I just ask that the file be returned to us for a moment? Thank you. May I return the file, please, Chair? Sorry about the interruption,
Okay.
but my team is giving me valuable input. Now, the amount we're referring here, Chair and Mr. van der Heever, to your supplementary statement. You give at the foot of that page that has been presented to you a figure of 3.5 million approximately, correct? That's the value
What
of the...
page is that on the supplementary?
I'm afraid I don't have the file in front of me, but I
Page
think it's
2
the second
of the
page.
supplementary.
What, page 2?
Page 2 of the supplementary.
Okay.
Yes, thank you, Chair, sorry. At the foot of the second page of that affidavit, you give a figure of 3.5 million. Is that correct?
That's correct, yes.
And was that the value of the orders placed on VR Laser prior to the change of ownership in VR Laser?
That's correct. By myself, yes.
I'm sorry?
By myself, yes.
That you had placed, yes.
That's correct. Yes.
Were there other colleagues within the organization who were also placing orders, or were you the only one who was placing orders?
There were other colleagues as well.
I see, but from your knowledge, from your own involvement, it was 3.5 million before the change of ownership in VR Laser that provoked so much media interest and subsequent investigation by the Public Protector and this Commission.
That's correct.
Thank you. And then if we can compare that with the value that appears in the affidavit that you have presented, of the 345 million, was that before or after or at the same time as the change of ownership? You look at page 111, your affidavit, paragraph 93.
Now that was for the whole period. That includes the wholes, everything up to 2018.
Right. And then if we look at paragraph 94, there you refer to a period between 2009 and 2015. The purchase orders then amounted to the value of 232 million.
That's correct. That was before the MOA period.
Right. Perhaps if, I'm sorry for the interruption, perhaps if I can ask the question really in this way. Before the change of ownership in VR Laser, what sort of amount was placed by way of the value of purchase orders compared with what happened after the change of ownership in VR Laser?
Well, there's a magnificent difference, but we didn't have a big contract at that stage, and that will explain the big change in figure.
So it was a big difference once there was a change in ownership.
That's correct, yes.
Right, thank you. Right, Mr. van den Heever, I'm done with this affidavit. We're going to deal with the other affidavit, which shouldn't take that long. But before we leave this, is there anything else you want to raise that you feel is significant to be brought to the attention of the chair in relation to the platform hulls issue?
Nothing that I can think of now.
Right, thank you. Thank you. With your leave, Chair, may we then turn to the other affidavit that has already been admitted.
Yes, that's Exhibit W14.1, starting at page 5.
That's correct, Chair.
Okay.
Thank you. If you have that in front of you, do you, Mr. van den Heever?
That's correct, yes.
Right, thank you. Some of the initial pages are pretty much stuff we've already dealt with, so we don't need to go into that. But this affidavit, as I understand it, deals specifically with an earlier contract, which is referred to as the Trunnion contract awarded to LMT.
That's correct.
And you deal with that from page 12. The heading is the Trunnion contract and the 12.7 million prepayment. Now, you've set out on pages 12 and 13 the procedure that was followed. Various entities were asked for quotations, is that right?
That's correct.
LMT was one, ELCA and IAD are the others, referred to in paragraph 15.
That's correct.
And then you refer to a proposal or a quotation received from some of these entities, such as LMT, paragraph 17, that from IATD in 18, and then you deal with your interactions with colleagues, Mr. Turbis, Mr. Burger, and Mr. Knutzer, and others.
That's correct.
Now, if we can just get to what appears to be the main focus of the affidavit from here at page 14, you refer to, in paragraph 24, that it became obvious that DLS was in negotiations with LMT on providing financial assistance to LMT. And you refer to your picking that up in relation, in a trail of emails. There were discussions relating to financial challenges that LMT was trying to address, and DLS was to provide some financial assistance. What did you understand was actually going on, and why?
Well, my understanding was that LMT had a cash flow problem and that they needed the assistance of DLS.
At that stage, was LMT owned by parties other than Denel?
I think so, yeah. They were not part of us yet.
Right. But there was a later selling of 51% shareholding in LMT to Denel.
Yeah, my understanding was due to this contract, which was not paid or something, resulted in becoming or getting the ownership in LMT. That's my understanding of it.
Okay. Thank you. Page 17 refers to a suspensive condition in relation to this contract. What did this relate to?
It was basically that if you don't get phase 2 of the Hoefyster contract from OMSCO,
Are you meaning that if you didn't complete phase 1, you would not get phase 2?
That's correct, yeah. And then due to that, there will be a suspensive condition, because suspensive condition refers to that.
Right. And did they in fact complete phase 1, LMT?
No, DLS didn't even, at this stage, hasn't completed phase 1.
Right. And then you deal with the termination of the contract, paragraph 41 and following. Was that the contract with LMT still, the same contract?
That's correct, yes.
And did you give the notice of termination that's referred to in paragraph 43?
No.
Who issued it? You say there you received a notice of termination. It was signed by Dr. Nel and Mr. Burger.
Yeah, I think it was a Mr. Deobardine that requested that documentation. It's somewhere in my statement. Let me just see.
Page 18, paragraph 42, perhaps that helps you?
That's correct, yes.
Right. Do you know why it was cancelled?
I'm not sure. I think it was due to the fact that the money was paid or whatever, I don't know, but there was no need for the contract
Can I take you
any longer, I think. I'm not sure.
I'm sorry to have interrupted you. If I may take you to page 45 and 46.
Yes.
This is an email from Mr. Dabidine, Darren Dabidine of DLS Financial Operations, is that right?
That's correct, yes.
And he attaches a signed cancellation letter. And is this the letter of cancellation that is referred to in your affidavit, the following page 46?
That's correct, yes.
I can just read it into the record. Second and third paragraphs. It is recorded that the said contract number has not yet come into effect as a suspensive condition as set out in clause 6312 of the contract has to date not been fulfilled. it is further recorded that Denel Pty Limited has recently acquired a majority shareholding of LMT Holdings. In light of the above, the parties have elected to invoke Clause 761 of the contract, hereby effecting a consensual cancellation of the contract. Cancellation notes will come into effect upon signature of the duly authorized representatives of both parties. And then we see there are signatures below that on the 21st of September 2012 by Mr. Burger for Denel Land Systems and Dr. Nell, then CEO for LMT Holdings. Right. Now, you then deal with another issue in your affidavit, which I'm going to try and deal with very briefly, Mr. van den Heever, and that is LMT purchase order. Can I take you back to page 18, your affidavit?
Okay.
You refer to a Malaysia transaction.
That's correct.
Now, you were asked to evaluate the feasibility of placing the manufacturing of the Malaysia LCT-30 turrets on LMT. Was the client there Malaysia? Were these turrets to be supplied to Malaysia?
That's correct, yes.
Not Arms Corps. This is different from the Hoefyster contract.
That's
is that
correct,
right?
yes.
And had Denel got that business to supply armored vehicles to Malaysia?
Yeah, it was just turrets.
Just turrets.
Which they delivered to Malaysia that was fitted on a Indian fabricated vehicle.
Right. And so this was business that could be given to LMT, is what your affidavit refers to. And then if I can take it to page 19, paragraph 47, Mr. Turbis indicated that DLS had to contract with LMT in this regard. It was in the process of being acquired by DLS, where DLS became a major shareholder, and its business strategy had to change. Were you informed of this by Mr. Turbis?
That's correct, yes.
And was this the reason why you understood the Malaysia turrets business must be placed on LMT?
Well, it made sense to me, yes.
Is that what you were instructed to do?
That's correct, yes.
And then you refer in paragraph 50 to an instruction from Mr. van der Linde to create urgently requisitions for the purchase order to be placed on LMT.
That's correct.
Right. And that was to a value of 10 million. And you've attached to your affidavit the relevant documents. We don't need to go through that, I believe, Chair. Now, what interests me, Mr. van den Heever, is at the top of your next page 20, you say, considering the deviation from normal procedure as stated above, the urgency attached, I was reluctant to execute the instructions of management. In what way did you believe that this was a deviation from normal procedure to place urgently a purchase order on LMT?
Okay, firstly, the procedure is to go out on quotation. And in other words, compile a RFQ, send it out to the supplier, get your quotations or to the 3 suppliers, which is part of your purchasing file that you need to have. And this was not followed. I was just given a quotation that came from LMT and request to place the order to that value, of which Mr. van der Linde loaded the requisitions that I used to place the order. And then the approval of order to that value of 10 million normally takes 2 to 3 weeks for approval, and this only took about 2 days for all the signatures.
In relation to the ordinary procedure which would have required going out for quotation, that would be the RFQ process of inviting 3 suppliers that you knew were suitable.
That's correct.
To invite them. Is a possible answer to that concern about the fact that the process didn't follow the RFQ process? Is a possible answer that, well, Denel was in the process of acquiring LMT. This was to improve the business strategy of Denel, and it would then make sense to Denel for its own purposes to try and give business to the LMT entity that it was about to acquire a majority shareholding in.
Well, according to me, you still need to follow procedure.
Right.
So,
So procedure still required that there would be a measure of competitive process,
that's
not
correct.
just with a company that's in the course of being acquired, but also to get benefit to Denel.
That's correct, yes.
Right. And then you deal on page 21 with tax invoices and an advance payment. Please explain to the chair what the significance is of the advance payment that was made in this regard. Who made what payment to whom and why?
Well, order was loaded by me and sent to LMT for signature,
Yeah.
and it was returned on the same day and invoiced the next day for payment of 5.7 million. And payment went through, so I don't know.
Was this according to standard procedure?
No, not according to me.
And was there a good business reason that you were aware of for such a prepayment to be made?
Only what was told to me by Mr. Tevis that the money will be paid back once LMT get their money from somewhere in the Middle East. I'm not sure what country it was, but they were expecting a amount from UAE or somewhere, and then they will refund this money. And if they don't refund it, then we will have the 51%
Right.
ownership.
Now you deal from page 22 to 23 to steps after the invoice was received from LMT, and then you had dealings with a Ms. Lavashni Chetty from your finance department, correct?
That's correct,
She
yes.
was wanting a copy of the agreement. You told her there had been no agreement except for the purchase order.
That's correct.
Were some purchase orders issued in terms of standard procedure without needing an agreement, or was a contract actually required in each case for this type of transaction?
Sometimes, depending on the value, but on this 10 million, there should at least be some sort of agreement, but there was no agreement, except for the order that was placed on the LMT.
And then you refer to a number of communications, I think all by email, with Mr. Yuri Himan, Mr. Dupree, Mr. Wynand Meyering, and they refer to a need to close the order and make the in paragraph 66, Mr. Dupree responded that you could close the order and make the quantity and price zero. What's that about, Mr.
Okay.
Heever?
When the order was loaded, the requisitions that was generated by Mr. van der Linde is used to create the lines in the purchase order. And that comes from a note where the project stores their money. And all the payments that was done on this never went through on that requisitions. It went through on advance payments and on different accounts. So those requisitions is basically unused, and it was just connected to the order. And then the project manager needed that money because I assume he paid some of the money from these advance payment accounts, was taken out of his notes. So he wanted us to close the order so that those requisition, the money that was, that 10 million that was allocated to that order, become available to his project again. Hope that makes sense.
Are you saying that there was an irregularity here?
Well, normally you should get a delivery against an order, a delivery note stating this is what we deliver, which then goes through the stores for receipt and invoice to finances to pay against the requisition that is linked to the order. This, we just received invoices and it was paid with out of an advanced payment account.
Now, in paragraph 70, page 23, you refer, after giving the background facts, to getting information from finance department showing that out of the 9.698 million rand, was that the value of the order itself?
I think that was what was paid out on that order of 9,698,370 was paid to LMT.
Yes.
And
Then you make a point about, of that, 9.225 million, with a shortfall of 472,000, appeared. What is the point that you're trying to make there? Is a difference, and you said finance department couldn't give you a difference?
yeah, if you go back, I think to point 69,
Yes.
finance verified that LMT paid the full amount back to LMT on the order. And when I got the information and did the calculation, I saw that there was, not all the money was received back, but 472,971 was still outstanding. But they couldn't give you explanation why.
Right, may I have a brief moment here? Mr. Van den Heever, thank you for your help. Those are the questions that I have. Thank you, Chair.
Thank you very much, Mr. Van den Heever, for coming to assist the Commission. If we need you, we will ask you to come back, but thank you very much. You are now excused.
Thank you, Chair.
Thank you, Ms. Interpreter. You are also excused.
Thank you, Chair. We are ready with our next witness. As I indicated, I don't believe that she will be that long. She
Yes.
is available. May we ask leave to call her? Her
Yes.
name is Ms.Carene Geldenhuis.
Yeah, that's fine.
And while she's coming forward, and before she's sworn in, may I just for your guidance refer to her affidavit in the same bundle, Denel 04. It appears from page 148, and we will be asking for it to be admitted as Exhibit W15. You should find the tab there. Sorry, just hold on. How are you?
Yes, thank you.
Thanks for coming. Sorry, you had to wait.
Yes, are you ready, Mr. Kennedy?
Yes, thank you, Chair. May we ask that your learned associate swear
Yeah.
the witness in?
Yes, my registrar.
Your registrar,
The
thank you.
labor court terminologist has stuck with you.
Old habits.
Yeah, thank you.
Please state your full names for the record.
Carine Geldenhuis.
Do you have any objections to taking the prescribed oath?
No, I don't.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence will give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated, Ms. Geldenhuis. I think you'll need to sit on the other chair, otherwise you'll be too far from the microphone. I think the other microphone doesn't work.
Much better.
Okay, all right.
Thank you, Chair.
Yes, you may continue.
Good afternoon, Ms. Geldenhuis. You have a bundle in front of you, a file. I hope it's been opened at page 151, if you look at the numbers on the top left. Right, thank you. Can you confirm that your name appears on this page, which is the first page of a statement?
That's correct.
Which you've in fact signed before a commission of oaths. If I may take you to page
Just 1 second, Mr. Kennedy. Just pull the mic closer to you. Yeah, okay, all right.
Thank you. May you, Ms. Geldenhuis, turn to page 165? Is that your signature on page 165?
That's correct.
And is it correct that, as seems to appear from the foot of the page, you signed that in front of a commission of oaths?
That's correct.
So this is in fact an affidavit. Chair, we would, I'm sorry, do you confirm that you have been through the contents of this affidavit
Yes, I have.
and that you confirm that in fact the contents of the affidavit are correct according to your own knowledge?
That's correct.
Right, thank you. Chair, we would then move formally for your leave to have admitted this affidavit, statement stroke affidavit with its annexes as an exhibit in bundle Denel 04 as exhibit W15.
The statement stroke affidavit of Ms.Carene Geldenhuis, starting at page 151, together with its annexures, is admitted as exhibit W15.
Thank you, Chair.
You may proceed.
Thank you. May we just for the record indicate, no, in fact, you were previously represented by attorneys, were you?
Yes, I was, when I was still employed by Denel.
Yes.
Yes.
Was that Mr. Pillay and his team?
No, it was Diali attorneys.
Diali attorneys,
Yes.
thank you. But you're no longer represented
No.
by them. Thank you. When did you leave Denel?
The end of March, no, the end of April, sorry,
Right.
2020.
When did you start there?
August, it was when I started, it was still BAE Systems, Dance Systems South Africa. That was in 2006. And then in April 2015, we were acquired by Denel, our business in South Africa.
And the business previously owned by BAE that was now acquired by Denel, did that then come to form a division within Denel?
No, it was a standalone entity
Right.
with its own board, but fully owned by Denel SOC.
So it's a separate company.
Yes.
What is the name of it?
It's Denel Vehicle Systems, Pty Limited.
Right. If we can refer to it from now on as
Yes.
DVS, as everybody seems to do. So it was DVS, and it's under its previous name, and then under the DVS name, that was your employer while you were employed in the Denel Group.
That's correct.
Okay, thank you. And what was your job title?
I was legal and commercial executive on the DVS executive team.
Right. Now we must bear in mind your affidavit was signed on the 15th of January 2020. We see that on page 105. So when we go to your first paragraph, page 151, obviously that was representing the facts as they existed in January 2020. You were still then employed at DVS.
That's correct.
Right. And you there refer to the fact that you were employed as the legal and commercial executive of DVS. So you weren't involved, or were you, in anything to do with DLS?
No.
Right. Now, On page 152, you refer to the area of business of DVS, that it has its own 3 divisions, and you describe that in some detail in 2.2, correct?
That's correct.
Okay. Chair, with your leave, I'm leading the witness on matters that I believe are
Yes,
uncontroversial.
non-controversial matters.
Thank you. And then you set out in 2.4 your key responsibility areas,
That's correct.
right? You refer to legal advice in 241 that you would provide the CEO and business
That's correct.
where warranted, and then also your functions including, as part of your key areas, drafting and reviewing legal documentation and agreements.
That's correct.
Right. Now, Ms. Geldenhuis, the Commissioner's already heard some evidence in relation to an agreement that was concluded between DVS and VR Laser. Is that, you deal it from page 153 with an instruction that you received to prepare a memorandum of agreement between DVS and VR Laser services.
That's correct.
And what sort of services were to be provided or goods were to be provided in terms of this agreement by VR Laser to DVS?
At that stage, we got an instruction through Mr. Hendrik, who was the acting CEO of Denel at that stage, to enter into agreement with VR Laser. We were not, because it was not something that came from within the business as a requirement, that we've identified VR Laser as to be a partner with us. We weren't quite sure what it is that we need to contract with them, what type of arrangement it was.
Yes.
We then took guidance from Mr. Jan Wessels, who was the COO of Denel at that stage, when he guided us to enter into a very high level, non-binding, non-committal type of agreement, wherein we will agree that we will explore avenues to maybe in future collaborate together.
Right.
And that was then the agreement that was drafted.
Okay, thank you. Now, you mentioned Mr. Nsepe, who was then acting group chief executive. We know that he took over then as the fully fledged group CEO when Mr. Saluji left Denel. He was the previous group CEO. Was Mr. Nsepe, when he was acting, was that at the time that Mr. Saluji was on suspension? Do you know?
I believe so.
Okay.
I'm not 100% in terms of the timeline.
All right.
But this was, I know that Mr. Saluji was suspended at the end of September 2015. This is in the beginning of November. So
Right.
I doubt it very much if there would have been a formal appointment already.
Okay. Now, you referred to the instruction coming from Mr. Nsepe, and your affidavit says that when that went through Mr. Steyn, you refer in 322 to Mr. Steyn as being Chief Executive Officer of DVS.
That's correct.
Now, did it strike you as normal or unusual that an initiative to enter into a contract with an outside entity such as VR Laser should come from the group chief executive rather than something that was generated within the division itself?
Like I've explained, we just became part of Denel. In the previous way that we did business under the BAE systems flag, it would have been very strange because the business would identify who they need as a partner and they would substantiate why they need that partner. It was strange that it came from the corporate office that we have to enter into agreement. But it was also, well, maybe this is the Denel manner. We were too new in the group to 100% say this is not the way that it's done.
So what were you instructed by Mr. Steyn to perform some duty?
Yes, I was.
And that was to prepare an agreement.
Yes, so I got a basis of an agreement from Mr. Wessels, which you will see in the pack, where he said, well, he's used this type of agreement before, and he suggests we use it as a basis. We then took that agreement, which is non-binding, non-committal, and we just amended it so that it fits into the current circumstances in terms of the type of business that we are doing, and then talking that we will then investigate further if there is indeed collaboration opportunities for the two businesses to work together.
Now, you refer to, in your affidavit, to two agreements being signed initially. The one is a confidentiality agreement, and the other a memorandum of agreement, your affidavit says. But may I take you to page 171? Do you have it?
Yes, I do.
This is a memorandum. The title is Memorandum of Understanding, and it's a 5-page document running to 175. Are you familiar with this document?
Yes, I am.
Is this the document that you refer to in your affidavit as the non-binding agreement?
That's correct.
All right. Did you draft this?
Yes, I did, but it was with input that I received from Mr. Jan Wessels.
Yes. And was that then finalized by Mr. Steyn signing it on behalf of Denel, page 175?
That's correct.
And it was signed on behalf of VR Laser by Mr. van der Merwe?
That's correct.
Right. Now, can we go now to the confidentiality agreement? That starts, it seems, at page 166. Again, an agreement between Denel and VR Laser.
That's correct.
Signed on the same date as the Memorandum of Understanding.
That's correct.
Right. Did you prepare the confidentiality agreement?
Yes, I did.
Right. Now, what did you understand the purpose of these agreements to be, the confidentiality agreement and the MOU? Let's start with the confidentiality agreement.
So, as it is reflecting in clause 3 of the confidentiality agreement,
Yes.
it was discussions and information to be exchanged that relates to the exploration of possible future collaboration between the parties to exploit the complementary capabilities there is between the parties.
Right. And then there's a reference to patent rights in clause 9 on page 168.
Yes?
And then if we go back to page 166, above clause 1 in the preamble, it refers to the parties and their addresses and so forth. And then on the 5th line in the top paragraph, that the parties desire to protect certain proprietary or confidential information which may be disclosed or exchanged between them both prior to and during the term of this agreement.
That's correct.
So was that the purpose of this agreement? If we're going to do business together, this agreement is going to ensure that VR Laser keeps confidential what we entrust to them in confidence.
That's correct.
Right. Now if we can turn to the MOU, the Memorandum of Understanding, page 172. Perhaps the easiest point by way of the overall objective is page 172 in the preamble. It refers to Denel and VR Laser, and then it says whereas. Do you have that?
Yes, I do.
Whereas DVS has as its main capability the development, manufacture and refurbishment of landmine protected and armored vehicles, which vehicles are sold to the local and international market. Whereas VRL is a local supplier of armored steel and has experience in the fabrication of armored capsules, inclusive of laser cutting and welding. VRL is an existing supplier of DVS, performs laser cutting and the supply of armored steel under subcontract of DVS, both parties realized that its capabilities are complementary, presumably their capabilities are complementary to each other, and requires further investigation into possible collaboration to the mutual benefit of both the parties. Right. So this was a memorandum of understanding, as you put it, non-binding. It was really, as I understand it, and correct me if I'm wrong, it was really a framework for the parties to agree to as a concept to move forward, then to negotiate a binding agreement. Is that right?
That's correct.
And it would be an agreement that ultimately would give business from DVS to VRL, or VRL, to provide specialist laser cutting and other requirements for armored steel relating to armored vehicles.
I think at the stage that we entered into this agreement, it was not the intention of the business to give some of the DVS business to VR Laser at that stage.
Right.
We entered into this agreement to see if there is something that is not part of our core capability that we can give to them. But we will need to have discussions with them to figure out what is there that we can give to them. It was never from the beginning the intention that we will give our main work to VR Laser.
Right. And then if I can refer you to clause 2 on the next page, 173, that sets out the general intention. The intention of the parties is to explore the feasibility to strategically collaborate and develop their relationship relating to future opportunities and the contracting models relating to such opportunity exploitation. The parties have identified the following as possible areas for collaboration, noting that this is not an exhaustive list. A, the possible future local manufacture of specialized steel structures in the RSA. B, the supply of steel products by VRL to DVS on a preferential basis. And C, the future optimal fabrication of armor vehicle hulls. It was really, we're going to now explore the way forward to see whether we can do business with each other.
That's
Is
correct.
that a fair reflection of
That's
what?
a fair reflection.
Right. And even the items in A, B, and C showed the sort of business that was going to be explored, but it wasn't an exhaustive list, as you put it.
That's correct.
Okay, thank you. Now, if I can take you back to page 154, you refer to, you deal in paragraph 3.7. Page 154, paragraph 3.7. You say, following the execution of the agreement on 2 November, it became apparent that Mr. Nsepe was not satisfied with the contents. Just explain to the chair, please, what the issue was.
We understood that Mr. Nsepe contacted Mr. Steyn and said to him that this is not the instructions that was given. What we've entered into is a non-binding agreement without an agreed work share, and this is not what was requested. It is requested that we entered into a binding agreement guaranteeing that there will be some work going to VR Laser.
I'm sorry, who was saying that?
As I understood it, this was communicated to us by Mr. Steyn, which was the CEO of DVS, who was my boss, and he was conveying it to his executive team, being the information or being told by his boss, Mr. Nsepe, that this agreement is not what they want.
Did you have any impression as to whether whoever came up with the idea to put up this non-binding agreement was actually trying to avoid getting into a legally binding agreement because he or she could see that there could be trouble here?
Well, as the executive team, we all knew about it, and this was, with Mr. Wessels, it was our plan. We are going to kick the ball into the future. We're going to do an agreement. It's not going to be binding, and we will
But you
see
could
what it
always-
is that we can do. We've got
You could say
the
we did
powers to
sign an
be from our
agreement.
backs, and we're going to go forward with our business as usual.
But you
It
could
did not
always
work.
say to Mr. Nchepe, you did sign an agreement.
We did say to him, we signed an agreement. He received the agreement, as far as I recall, and then a day or two later, he was
This is not what I wanted.
No, he was angry.
You and your team were caught out.
We were cheeky that way.
Yes, Mr. Kennedy.
Thank you, Chair. But just so that I understand fully, was the intention never to take the matter forward from the executive point of view, that as far as you understood it, with the MOU, or was it a genuine intention to negotiate further with VR Laser once the MOU was signed?
We did not really understand what it is that we need to contract with them for.
Yeah.
I mean, it was incomprehensible. We've got our business. Now we are asked to enter into agreement with another business, but for what? I mean, it was so there. You will see throughout my affidavit, there's various actions we took and brainstorming we did and feedback that we kept on giving and say, but this cannot work, and this is why it cannot work. So we were told, enter into agreement, and we entered into agreement. It was not binding, but let's see if there is something that we can do that's not giving away our core capabilities and our main business. And yes, there was a real intention to see if there is on the side something that we can give to them, but the intention was never to give our core capability or our core business to them.
And did you contemplate that, if at all possible, you wanted to postpone for as long as possible the day when you might have to tell them, but we have a problem with this?
That's exactly the way that the contract is structured. You will, and I might be jumping now into what you will lead me to. So what we did is we first entered into a non-binding agreement, and then it was said, no, better you go for a binding agreement. There was various, and we must probably go through it, iterations, how it ended up, what the binding agreement looked like. But there is a little rider that we put into the agreement where we kept on, we were saying, okay, we will do that, but on condition that we need to look at a couple of things. And in our mind, if we get there one day, we will fight the fight again, that it will not make sense for us as a business to give our work to VR Laser. So as an executive team under Mr. Stein's leadership, we felt that we were keeping our back door open a little bit, although we are not upsetting our leadership in the Denel group too much.
Yeah, okay.
So you were trying not to upset the leadership, the acting group CEO in particular at that time, but am I right in understanding you were saying you felt uncomfortable from the beginning?
We were extremely uncomfortable.
Right. One thing I omitted to take you to, and I apologize for this, Chair, is that when we refer again to page 175, the signature page of the MOU, your affidavit refers to the signature having happened at the offices of DVS when the representatives of VR Laser were present.
That's correct.
Were you yourself present when this was signed?
I was not present in the meeting, but the meeting took place in Mr. Stein's office, which is directly opposite my office, and it is glass offices. So I could see the meeting happening, although I was not in the meeting.
Now, are you aware who actually attended for VR Laser? It seems to be signed by Mr. van der Merwe.
Yes.
But your affidavit refers also to a person being present known as Kamal Singala.
That's correct.
How do you know that he was present if you weren't there? Did you?
Like I said, my office is here.
Yeah, she said it's a window.
It's over
She could
here.
see.
And Mr. Steyn, during this instruction came to enter into agreement like in the day before.
Yeah.
They were in his office while I was sitting across the aisle
The
drafting
passage.
and finalizing it.
Okay.
So he would walk in and out in my office to find out how far am I with the agreement already. And I know they were in there. I might have walked
But
in there.
Sorry to interrupt. What I'm interested in, how do you know that you knew some people were there and you knew what they were there for? But how did you know it was a Mr. Singala? Did Mr. Steyn tell you, or were you introduced to Mr. Singala, or did you see an attendance register?
I think I was CC'd on the invitation, the business invitation,
Okay.
the Outlook,
Right.
and that says Kamal Singala.
Fine, thank you. And then your affidavit refers to a rumor mill. You found out through the rumor mill that Mr. Singala, in fact, has a fuller name. It's Kamal Singala Gupta.
Yes, only later on.
Okay. All right. Now, you've mentioned that Mr. Nsepe was unhappy. You deal with that in 3.7. And one of the points that he was unhappy with was that it was a non-binding agreement. It was not yet a binding agreement. And there's reference also to his complaint that about a single source supplier. What did you understand Mr. Nsepe's requirement to be?
I want to come back to my evidence earlier on. We were quite new in the Denel stable. So the PMFA and the triple PMA, we weren't accustomed to it yet. So at that stage, when the words single source supplier was used in our environment, it was just exactly the same what the layman will say, single source supplier. So it was not linked back to exactly how we would, from a supply chain perspective, from a state-owned entity, look at a single source supplier. So to us, it's team with these people, and you're going to have a type of exclusive agreement with them to work with them.
Right, so you will procure something exclusively from
Yes.
VR Laser.
Yes.
What would that something be that you understood Mr. Nsepe desired?
We still did not know at that stage. So from it only later on panned out that they were most talking about that they want us to do all our whole manufacturing at VR Laser. So throughout this period that we were entering into new agreement or entering and discussing agreements, it came out that they are talking about whole manufacturing at VR Laser. Although we started off, let's see what there is that's not part of our core capability that we can give to VR Laser.
Right. Now, your affidavit then goes on to talk of email and other communications involving yourself and Mr. Steyn with Mr. Nsepe. Is that right?
That's correct.
And Mr. Wessels was also involved at a certain stage. We'll get to that in a moment. But what did management feel? What did you at the executive level of DLS feel once it was clear that what Mr. Nsepe wanted was, firstly, immediately, rather than through an MOU and some negotiation and exploring the way forward, rather go straight for an actual binding agreement? Secondly, that it be a sole supplier, single supplier. And thirdly, that what needed to be supplied included construction of hulls.
I just want to correct you. It's DVS, not DLS.
I beg your pardon, I
No,
meant
it's fine.
DVS. Thank you.
So we were at this stage being told that there is already an agreement that was entered by DLS
Right.
with VR Laser.
Right.
And that they would suggest then that we mirror the type of agreement that DLS has entered into with VR Laser. So there was then stages where they said, well, let's combine DVS and DVS become a party of the DLS and VR Laser agreement That posed various issues in terms of the amendment of the agreement, because DVS is not a division of Denel, it's a separate legal entity. And then it was decided, well, the best and the fastest route for us to go is to enter into a similar agreement that the DLS had with VR Laser. Yet again, that's where we did a little bit of changing, sort of giving ourselves the opportunity to get out of this agreement, should the business case mean that we are not bound by this agreement.
Right.
But your position seems to have been clear, that your position at DVS, that you had no need to go into any agreement with the R Laser.
That's correct.
You were fine.
That's correct.
Yes. Okay.
Now, your affidavit refers at the top of page 155 to DVS having the necessary fabrication capacity, and that it was required to run pre-production pilot fabrication to industrialize hulls for specific vehicles. So was what Mr. Nsepe instructing you to do, to move from a non-binding agreement about talking about the future to something that was binding, which would include fabrication of hulls? Was this something that could be done in-house by DVS itself?
Absolutely. That was our core capability.
It was your core capability?
Absolutely.
Right. And then you refer to Mr. Steyn in 3.10, informing you about a meeting earlier that day where the strategic intent of the Denel Landwood business was conveyed to VR Laser, and it was explained that the signature would follow after the approval of the board. What does this relate to, the Landwood business strategic intent?
After we have been acquired, the DVS business by Denel, there was a lot of talk, let me rather say, after if I recall correctly, after the suspension of Mr. Saluji, there was a lot of talk that the Landwood business will consolidate, which will mean that it will be DLS, DVS, and LMT that we will consolidate. But there wasn't a proper manner in which we're going to do it, and there wasn't a real direction what the type of legal entity would be. It was just this cluster that will have a joint vision. And this is then talking to the cluster, being those two divisions, and our business's joint vision as it is envisaged by the DCO teams.
Yes. So are you saying this, and correct me if my understanding is wrong, within Denel you had various entities that included LMT, that was controlled by Denel with a 51% shareholding. You had DVS, that was a company on its own, but fully owned and controlled by Denel.
That's correct.
LMT had certain core business of its own. You had core business of your own, which had previously been conducted when it was owned by BAE, correct?
That's correct.
It had now been brought within the Denel group. You had capacity, and what was now being intended in terms of the Landwood business strategy was to try and enhance the in-house capability for such products, that you would work together and maybe ultimately restructure. So the focus was to carry on your respective core businesses in a coordinated in-house way. Is
That's
that correct? Right. Now, the proposal...
I just want to add
Yes,
here, this
please.
was very early stages, very high level.
Yes.
The detail was never
Right.
flushed out. So
Yes.
it was very much blue sky statements that was being made. Definitely for us in the business unit, there was no tangible plans at this stage understanding how it will work, how it will flush out into the day-to-day of the businesses.
I understand. So it was at that stage just a broad strategic vision.
Yes,
Right. And did you understand that that broad strategic vision is what had been decided on at the executive level, even above you,
absolutely,
at board level of the group?
absolutely.
Right. And
Board, executive level at the group, I'm not sure where.
right. So although you hadn't got into the nuts and bolts of how this was going to be realized, this vision, that was where the group wanted to move.
That's correct.
Now, how did you find the instruction from Mr. Nchepe at the level of Group CEO, acting Group CEO, that now some of your core business should be contracted out on a sole supplier basis to VR Laser?
It did not make sense to us.
Right. Now, your affidavit in 3.10 at page 155 refers to Mr. Steyn giving you feedback on a meeting that he seems to have had with that day with VR Laser Services, where he was trying to explain to them, VR Laser, that this approach had to be subject to the landward business strategy. Do you understand why he was explaining that to VR Laser? Because they're outside the group. Isn't it an issue that he should have had with Mr. Nsepe?
I think at that stage, and I don't want to put words in Mr. Steyn's mouth, I think he was very much aware that through the VR Laser channel, there is feedback into the executive level in Denel. What I was referring to in this paragraph is, and it's supported by the emails that I attach here to, is where Mr. Steyn explained to Mr. Van der Merwe that we cannot just enter into an agreement and say, okay, we're going to give you some of the work. We as a business, we've got an integrated business plan that we've prepared for a 5-year period when we committed that we will give a certain return to our shareholder. If it is that we need to change and take some of our core capability and our core work out of our business plan, then we will have to change our business plan and go back to the Denel board, who is the authority that approves our business plan. They then need to see what is the impact of us taking out our business out of our own business plan, and they need to authorize it. So this is the reason why they kept on referring, it needs to be approved by the board, because the board needs to see the impact financially, what it will mean to the DVS business if we take the business that rightfully belongs then to DVS and we place it on VR Laser.
Now, did Mr. Steyn of Van der Merwe, who was the CEO of DVS?
Mr. Steyn.
Mr. Steyn, did he ever tell you or his team that he had confronted Mr. Nsepe and say, but I don't understand what you are asking us to do. Tell me I don't understand the logic. Why do we need to give some business to these people? And if he said he did, what answer was he given? Because from what you have said, it's clear you and the team at DVS, which must include Mr. Steyn, didn't see the need for DVS to give some business to VR Laser. So, but did he confront him and say, give me a rational reason, I don't understand why you want us to do this? And did he give him any reason?
I cannot answer that question. What I can answer is that continuously Mr. Steyn, through correspondence, which is added to my affidavit, and from our business, we continuously conveyed to DCO and Mr. Nsepe why this cannot work. So we reiterated why it cannot work. I do not bear knowledge whether
that there were meetings between yourselves from DFS or DVS or some of you with Mr. Nsepe, maybe other people, where you did tell him this, or
where we did tell him this cannot work for our business.
in a meeting.
I do believe, not where I was present, but
No,
I
yeah.
do believe if
terms of
I look
documentation.
at the correspondence which I was
Yes.
copied into,
Yes.
it does look like there have been meetings where Mr. Steyn was present, and some of them where Mr. Wessels was also present, where they explained or tried to explain to Mr. Ntsepe why this cannot work and does not work for our business.
And there is no indication that he had an answer for them, a proper
Not
answer.
to my knowledge.
Yeah. Okay, all right.
Thank you, Chair. On this point, may I take you to an email that, as you point out, is referred to in your affidavit. Can I take you, please, to page 185?
I've got it.
It's referred to as Annexure CG 4.1. I see in your affidavit you refer to CG4, but is this the CG4 that you're referring to as
That's
an email?
correct.
Correct, thank you. Now, this is an email. Let's leave aside the top section because it seems to have been forwarded at a later stage. But the actual email starts about a third of the way down. Do you see under in bold print 13 November? Then there's a little table which shows the subject and the person who's sending it and date and so forth, the usual email heading.
Yes,
And that is sent from Johannes Steyn, that's your CEO,
that's correct.
DVS, and it's addressed to Piet Kruger.
Yes.
Who was he?
He was the
Which entity?
CEO, he was from DVS,
DVS.
and he was the operational executive.
Okay. And then it refers to yourself, is that right? Carene
That's
Geldenhuis?
correct.
Percy Ndaba, also a DVS colleague.
Also DVS colleague, he was at that stage, I believe, the general manager of Gear Ratio.
Okay. And then, is it Aubrey Duplessis was copied in?
That's correct. He
And-
was the director of programs
A
and
director
IT at DVS,
of DVS. So he
Yes.
was on the DVS board.
executive team. So
Right.
both Kruger, myself, Ndaba and Duplessis was part of the DVS executive team.
Okay. Then it's also copied to Jan Wessels. And
That's
he
correct.
was the group COO
That's
at
correct.
the time. Is that correct?
That's correct.
So he wasn't working within DVS. He was above that at head office.
That's
at
correct.
group level, reporting to Mr. Ntsepe.
That's correct.
Right. And then who's the other person? Odwa
It was-
Mshwana?
Odwa Mswana. Odwa was at that stage the acting CEO of Denel after Mr. Soloji and Klontlu were suspended. I need to say that Odwa came with us from BAE Systems. So there was at this stage, a very close relationship between us because it was one of our colleagues that was now pulled
Yes.
up to head office.
So although he was a bit distant now in the sense that he was elsewhere within the group, no longer in the DVS
That's
entity
correct.
itself, you still had that historical connection
That's
and
correct.
relationship. Right. Now, this appears to be a report back from Mr. Steyn about a meeting.
That's correct.
He refers, he says, apologies for the lengthy email. I got stuck on the RG21 on my way back to the office from DCO. Due to the urgency of the matter, this cannot wait until Monday. So as far as you as an executive team within DVS were concerned, was this viewed as something significant and important?
Yes, it was.
And then he says, following Zwelaki's request 2 weeks ago, is that Zwelaki and Sepe?
That's correct.
Right. To finalize a formal agreement with VRL for the fabrication of our hulls in future, several interactions take place between DVS and VRL to start the process, evaluate VRL's capability, looking into the negative effect of such an agreement on our fabrication workshops, recoveries, etc. I had a follow-on meeting with Zwelaki, Jan and Odwa yesterday on the progress and next steps. So he seems to be saying, we received this instruction, we're trying to deal with it, take it forward. One of the things we have to look at is the negative effect that such an agreement would have on our business.
That's correct.
Did you understand then there to be some interaction between Mr. Steyn, who was the head of the executive of DVS, with his superiors at head office,
Yes,
acting group CEO, group COO, and CFO.
that's correct.
Right. And then he says, attached a few slides originally drafted by Jan, updated following the meeting yesterday to illustrate our intent and clarify current opportunities for VRL. Zwelaki asked that Jan and I meet with VRL today and share this with them. Peter van der Merwe, the CEO, that's VR Laser's CEO, is that
That's
right?
correct.
Then he says at our meeting, Jan and I explained that DVS has a fabrication capability. Now, is that confirming what you said earlier? You could make these things in-house.
Absolutely.
And that we are required to run pre-production pilot fabrication to industrialize hulls of specific vehicles. Pre-production quantities can vary depending on customer requirements, etc. In the next line, in the end, we agreed that a more appropriate way to approach an agreement is to use the DLS VRL agreement. That's the DLS, that's your sister entity. Well, you were a separate company, but DLS was an operating division of Denel itself.
That's correct.
And so the agreement reached, it seems, between Mr. Steyn, Mr. Wessels, and Mr. Schlontlo with VR Laser is that to accommodate the concern about the giving of business to VR Laser, despite the fact that DVS had an in-house capacity, was to follow, as an example, another agreement which had already been entered into by DLS with VRL.
That's correct.
And that would be to, ending up with a Denel Landwards VRL agreement excluding LMT. Jan's request is that we draft the appropriate clauses, principles, and potentially amend the DLS VRL agreement to incorporate the DVS part and finalize it by next week, Friday. Peter will forward the word version. And then there's discussion about Jan explaining that how it would be done by way of Denel board approval on the 7th of December. Then he says this is the background leading up to what needs to be done now. 1, finalize the detailed fabrication workload over the budget period, 5 years, based on our current budget. Percy will complete this. 2, calculate the negative effect on recoveries. Now, what are the recoveries that are referred to there?
So we've got a baseline for the amount of people that we've got, and we have to sell a certain amount of vehicles or product, whatever it is, to cover the amount of people and the overhead cost that we've got. So if we don't sell enough, we have got under recoveries or we've got over recoveries.
Okay, and then 3 on the top of page 186 is the next step is to draft the additional clauses required to cover DVS's part in the current DLS VRL agreement to include the principles and outline very high level on the last slide. Here was some guidance, so he's giving you some pointers as to what you should do in drafting the clauses based on the DLS agreement with VR Laser.
That's
is that
correct.
right? And one of them is in A. Other than in the DLS case, the preamble should include the fact that DVS has a world-class fabrication facility capability. VDS requires a high-quality hull fabrication supplier partner to manufacture hulls for production that meets the requirements of government's Black Industrialist Program initiated by DTI, and in our opinion, VRL meets such requirements. Now that seems to raise 2 issues. The one is that mention would be made that DVS, I beg your pardon, it's late in the day. DVS has its own capability, but now needs somebody that is a top-class supplier of particular items. Now, had your view changed, or were you persuaded that DVS couldn't provide all of this in-house?
No, at that stage there was, and this is exactly what he referred to, a white paper, if I recall correctly, about Black Industrialist Program that the government wished to roll out.
Right.
And it was then decided that we will use this Black Industrialist Program at least as some sort of justification why we are entering into this agreement, because we can't just follow the DLS agreement, because they say in their agreement they don't have the capability to do it. We've got the capability. We have to state that we've got the capability. But now you have to rationalize, if you've got the capability, why is it that you need to outsource it? And this is the best and the close to getting to somewhere wherein you look then at the Black Industrialist Program. I have to say, I know there were talks about it. I can't recall the detail of the program. So unfortunately, I can't comment further on the program.
You must have been in a difficult position at DVS,
We were in an extremely difficult position.
because it seems to me that you could see that there was something untoward into this whole thing. You had discomfort associating yourselves with it. You had discomfort being party to any agreement that would give VR Laser some business in these circumstances where you were satisfied you had all the capacity to do the work that you were doing. But at the same time, you seem to have had some pressure, and you had to try and walk quite a tightrope between having to incur the wrath of your top leaders or lose your business, your core business. You had to try and say, how do we strike a balance and still not do what seems to us to be wrong, but at the same time still be there or not lose. Does that reflect more or less what you think your situation was?
It was definitely what our situation was. In hindsight is always a perfect science, but when we were in the happenings, I think the business rationale for this does not make sense for us. We are an oil business. We know what we do. We've shown profits. We are good in what we are doing. It does not make business sense for us to give our business away to anybody else. That was a bigger drive for us than whether it was VR laser, whether it was for DLS, whether it was LMT. The drive for us is, why must we give our business away? So at that stage, the red flags was definitely on our level,
Yes.
not what we know now.
Yes.
It was more, why do we, business principles, this does not make sense.
Yes. So it was based on your assessment of your business.
Absolutely.
To say we don't need to do that. But obviously, if somebody keeps on saying do it and you can't understand why you must do it, your thoughts have got to start wandering.
Yes.
Yeah. Okay, all right.
Thank you, Chair. Ms. Geldenhuis, so this email correspondence that we've just looked at wasn't copied into Mr. Nsepe according to the email address list, but it was copied into Mr. Wessels as COO, Group COO.
That's correct.
And he reported to Mr. Nsepe, then acting Group CEO.
Yes, so both Mr. Wessels, Mr. Mswana, and Mr. Steyn reported
Yes,
to...
indeed. Mswana as well.
Yes.
At Group
Yes.
head office level. Right. Now, just the slide presentation that is referred to in the email, is that the set of 3 slides that we see, or 4 slides that we see from page 187?
That's correct.
And what did this did this depict what the objective was for this landward objective to incorporate a VR laser that they had in mind?
According to Mr. Steyn, yes.
Right.
So this was very high level. It was not on the executive level of the business discussed, or it was
Right.
for information for us.
Right. Now, to the extent that an email earlier suggested that if you followed the DLS, single supply agreement with VR laser, that might somehow bring it within the landward strategic objective of Denel to try and keep things in-house. In your view, was that possible? Was that feasible?
Just repeat the question, please.
Yes, sorry, I wasn't very clear. You gave evidence earlier about this landward strategic policy that
Yes.
Denel board had already adopted. They brought in what was previously owned by BAE,
Yes.
that then became DVS, your
Yes.
company. They already had their own capacity in other divisions as well,
That's correct.
and they had bought a majority controlling share in LMT.
That's correct.
And all of your entities and businesses had certain core capabilities and
That's
capacities. And in your case, that included as part of your core business the ability to manufacture hulls of armored vehicles.
That's correct.
Correct. And you said earlier the strategic objective was to try and enhance the in-house capability.
That's correct.
Right.
I also just want to say the direction or the strategic intent, it changed quite often.
Right.
So I won't know at this stage what it was, where it was,
Okay.
whether it was let's consolidate and be one company and we bring you in and we divisionalized you, whether you're going to stay on your own but we're just going to manage you,
Yeah.
whether it was very fluid.
Yes, you testified earlier that how it would be achieved would be something that would still be developed.
That's correct.
But at this stage, were you under at least the understanding that that broad objective was still in place?
Yes, it was.
Okay.
But there was also an understanding that there was a strategic agreement that was being entered into a VR laser.
Yes.
For what, I don't know.
I'm really just
for
asking.
the bigger part of the business.
Yeah.
I mean, we knew we didn't understand for our part of the business why we need to do it. So the rationale why it was there for the bigger part of the business was never shared with us.
Right. But what I'm suggesting to you, and just ask you to comment on, one way of looking at it perhaps, is that if you have an objective that tries to keep in-house, it doesn't make sense to go out of the Denel's divisions and companies, including
No.
DVS, to now start getting some of your core business done by VR laser.
No, it doesn't.
Do you share that concern, or do
Yes.
do I summarize what your concern was?
It's 100% correct, because if we would have done that, it would have meant that DVS would have ended up in a systems house and not with a manufacturing capability. And that was not what our main business was. Our main business was physically manufacturing.
May I ask you then, please, Ms. Geldenhuis, to turn to page 191.
Yes?
The email halfway down seems to be an email from the 13th of November 2015. And it appears to come from, is it from Mr. Steyn to from Mr. Steyn, yes? Is that right?
That's correct.
And it seems to be addressed in confidence to Jan, that's Wessels, and Odwa, that's Mr. Mshlontlo.
No, Mswana.
I beg your pardon, Ms.
Yes.
Schwan. Yes, thank you. I beg your pardon. And then, I don't want to go through all of this, but you've mentioned this in your affidavit as being an email that Mr. Steyn shared with you to show that he'd expressed concerns with Mr. Wessels and Mr. Mshluana. Is that right?
That's correct.
Okay. And then if we look at the top email, that is from Jan Wessels, back to Mr. Steyn. Again, their colleague, or Mr. Wessels' colleague, Mr. Mshluana, was copied in, and it's headed Pitfalls and Concerns, Fabrication Outsourcing to VRL. And then he says, refer my email response to your earlier wider email. That is the best approach I can advise. Present sober and professional delta business impact plus and minus of such potential scenario to board, 7 December. That is why no decision can be finalized before that point when shareholder made his choice. Important to quantify every parameter fairly and objectively, the pluses and the minus deltas, and doing so not to be seen against change in principle, though. Now, what did you, and if I may just mention, Mr. Wessels himself has been providing evidence to the Commission, but I just want to ask you, from your discussions with Mr. Steyn and your colleagues in executive management at DVS, what did you understand was happening between Mr. Steyn and Mr. Wessels? Was Mr. Steyn raising concerns along the lines that you have raised with the chairperson today?
Yes.
With his colleague who was his superior in the group, Mr. Wessels,
That's
and his
correct.
colleague also superior, Mr. Mshluana.
Mshluana.
Mr. Mshluana, I beg your pardon.
That's correct.
I do beg your pardon.
That's correct. And then the coming back yet again, we were new in the group, so Mr. Jan Wessels was the COO. So Mr. Steyn at that stage leaned quite on him because it was guiding into the group as the COO, with him as well.
Yeah.
And Johan kept raising the concerns that we've got. We've drafted lists, we've made calculations, we showed what our concerns is. And then Jan, I do believe that he tried as well to convince Mr. Ntsepe that this is not the right, and you will see it from the emails, that this is not the same scenario as the LS scenario, because they don't have capacity or capability to do hull manufacturing, and that it can't be seen as exactly the same. That Mr. Wessels eventually said, well, the best thing that you can do now is the board needs to decide. You will have to tell the board what is the impact of this agreement. If you enter into this type of agreement, what is the impact? You will show it in your business case and your business plan for the next 5 years on the board meeting that was scheduled for the 7th of December. And then the board needs to decide what is it that they want to do. Does the board want you to enter into an agreement like this or not?
Right.
This is what I understand from this email.
Okay. Thank you. And then I'd like to refer again to the email from Johannes Steyn to Mr. Wessels and Mr. Mshluana at the foot of this page 191. We've dealt with that, but what I'm interested in is the following page immediately after the heading or the conclusion regards Johan. There's a heading, Fabrication Outsourcing Considerations. In my copy, I assume that everybody has the same color. It's in brown,
That's
light
correct.
brown or tan. And there are 16 points that are considerations relating to the outsourcing of fabrication. Who do you understand these to be considerations? Who do you understand to be the person listing these considerations? Was that Mr. Steyn or who?
So how this list came about was Mr. Steyn requested myself, Aubrey du Plessis, Piet Kruger, and Percy Ndaba to brainstorm if we go through this agreement, what the impact would be on our business. And we had a off-site strategic session, and we just in a 10, 15 minutes, compile this list to indicate what we see as the executive team or a core part of the executive team, why this agreement would be problematic. And you will then see in the email on the previous page where he then actually informed Mr. Wessels and Mr. Mulwana that this agreement was drafted by his team and there was no influence from his side. I think at this stage, it must be said that Mr. Steyn was now obviously at this stage seen in the group as being blocking all the agreements because he just didn't, he kept on coming back and saying, no, this cannot happen, this cannot happen. So it was seen, or he was seen, and most probably then the executive team of DVS was seen as being a little rock in somebody's shoes.
Okay, if we can look at as you point out, the email itself refers to what you just said about him not giving the input. It was from a collective team effort. Back at page 191, email at the bottom, in the first paragraph, at our exec team offsite earlier this week, I asked Aubrey, Piet, Percy, and Carene, that's yourself.
That's correct.
To form a small team and brainstorm all the issues, angles, concerns with respect to outsourcing our fabrication work. Below an unedited version of the list I've received an hour ago, we will use this list to ensure we cover most of the potential pitfalls in the agreement with VRL. Most notably of it all is the general view, not influenced by me, that this would not be the right thing to do. Right thing to do from whose perspective?
From DVS's perspective.
From DVS's perspective. And then he puts in brackets item 1 and 2, and then he puts 4 exclamation marks, I beg your pardon. Then if we go to look at items 1 and 2 on your list at page 192, the first 2 items are DVS will lose a core competency, a real competitor will be created. Was this a serious concern on your part and your colleagues' part?
Absolutely.
Right. And then 3, the outsourcing of all fabrication will rob DVS of the opportunity to develop fabrication, QSEs and EMEs, for the purpose of empowerment. What's QSEs and EMEs?
It's micro enterprises and qualified enterprises. It's part of the BE scorecard and how you develop
Right.
the industry,
Right.
as well as previous disadvantaged individuals.
What about
Or
a possible counter-argument that, well, if you're giving it to VR Laser, if they have black empowerment credentials, aren't you achieving the same thing?
Yeah, but I don't think that they were the qualified enterprises or the micro enterprises.
I see. And then the 4th point, hull fabrication is critical for protection, and the accountability and reputational risk will remain with DVS, but the responsibility will be with another party. Just explain that to us, please.
So when he's referring to protection, he's referring to landmine protection.
Right.
So the fabrication of the hull is critical for landmine protection, and the accountability will remain with us, but the responsibility to ensure that there is landmine protection is now outsourced to another party. So we will take the risk, but we are not 100% in control of the risk.
So you would be accountable
Yes,
if, for example, soldiers are blown up in an unsafe armored vehicle. You would have to be accountable, but you haven't manufactured it. You've got somebody else to do it, and
that's correct.
you're leaving it to them to achieve the standard.
That's correct.
Okay, thank you. And then I'm not going to deal with all of the other issues, but I just want to highlight a few. 7, consider PFMA requirement, that's the Public Finance Management Act, that an entity must preserve and protect its IP and capability, and then highlighted in yellow, Carene to check, that's yourself.
That's correct.
Right. And then the other point that I would highlight is paragraph 10, retrenchment or reallocation of current resources in fabrication must be considered. So one of the various other items that you were concerned about is that there could be implications for having to retrench people who were employed in fabrication in the in-house capability if no longer were they doing the fabrication.
That's
Do
correct.
I understand you correctly?
That's correct.
Thank you. Now I'd like you to go to another chain of emails that we find immediately following that. That's page 193 to 195. Let's start at the email in November on page 194 from Jan Wessels. "17th of November 2015. That's an email from Mr. Wessels to Mr. Nsepe.
That's correct.
It was
What page is that?
I'm
I'm
sorry,
at 193.
194.
Oh, okay.
About a third of the page down, you see from Jan Wessels, sent on Tuesday, November 17, 2015. You with me, Ms.
Yes, I
Geldenhuis?
am.
And it appears, and I'm not going to go through this all, but it appears that Mr. Wessels was raising some of the concerns that had been raised by Mr. Steyn.
That's correct.
And he refers to a meeting on the 13th of November, which had included Mr. Van der Merwe from VRL and Mr. Steyn and Mr. Wessels himself. And then he says, do you see a number of bullet points?
Yes.
Yes, in fact, before we get that, I think I should read into the record, if I may, Chair, the next sentence. I have to
Yes.
repeat again that the process and complexity differs from when DLS appointed VRL as preferred single source hull fabricator. DLS had no in-house capability anyway and used a variety of outsourced fabricators. From now, with DVS having a strong in-house capability which needs to be converted in an optimal way. Am I right in understanding he was raising the point that you've gone into in some detail with the chair to say in DLS's case, they didn't have an in-house capability, so it might make sense to have an outside provider on a single source basis, being VR Laser. But you were different. Here, DVS, as opposed to DLS, had its own in-house capacity, so why
That's
contract it
correct.
out?
That's correct.
Is he referring to the same point as yours?
Exactly.
All right, thank you. And then he says the following were discussed in detail on Friday the 13th of November at the meeting. And again, Chair, I'm not going to go through everything, but just focus on a few. The first bullet point, the model of strategic cooperation envisaged between DVS and VRL in the context that DVS has a big in-house fabrication capability, including people, facilities, infrastructure that will need to be migrated to VRL, partially or fully when an agreement is reached. Again, it seems to be raising at least some of the points that you have also mentioned as problem areas that rang some alarm bells.
That's correct.
Okay. And then there's reference to discrete programs, practicalities, timelines. And then the fifth bullet point is acknowledged by both sides that the DVS business plan budget for 2016-17 plus 4 years will be affected. DVS becomes more of a systems company than a manufacturer. Did you understand that that was where DVS would be heading if it entered into this agreement with VR Laser, where a lot of your core business was manufacturing, which was now to be done by VR Laser?
Yes.
Right. And it says, as such, Denel board will have to sign off the partnership by virtue of approving the revised budget. And then he refers to the way forward. A draft binding agreement will be constructed, and then it will be referred to various parties, etc. Now, so, and then we get a response from Mr. Nsepe, at the top of this page, but can we start at the foot of page 193, where we just see in the last 3 lines, do you see from Zwelaki Nsepe?
Yes.
Sent on the 17th of November at 8:44 a.m. to Mr. Wessels, copied in Mr. Mshluana, as well as Stefan B. And Johannes Stein. And this is what he says. Hi, Jan, your email is too long. And as you usually say, some of the issues you put on...
I'm sorry, Mr. Kennedy. I've lost you.
It's the top of page 194, line 3, Chair.
Oh, the top one.
That's correct.
Okay, all right.
So this is an email from Mr. Nsepe replying to the lengthy and detailed email that Mr. Wessels had sent him, raising inter alia the concerns about the impact this would have on DVS's core business.
That's correct.
Okay, so Mr. Nsepe comes back with a very brief email. He says, hi, Jan, your email is too long. And as you usually say, some of the issues you put on paper can be discussed. You forgot to mention that I showed you, Johan, Odwa, and now a Stefan, I'm not sure exactly what that means, a letter coming from the chairman instructing me to divisionalize and optimize DVS and DLS and show savings whilst the process is being carried through. I've asked Johan and Stefan to do just that because we were taking too long to come to a final conclusion on this matter. This process will of course involve you as a third independent party. We are required to present a plan for the board, and I've asked Stefan to take the lead on this. Were you made aware of this response from Mr. Nsepe?
Yes, we were.
We see that he criticizes Mr. Wessels firstly for being too long in his email, and secondly for raising issues that perhaps require rather discussion, presumably not discussion by email but face to face. And then the rest of his email seems to be saying he's under pressure from the chairperson to make structural changes within Denel, and the matter was accordingly urgent. Were you aware that whether Mr. Nsepe in this email or anywhere else actually got to grips with giving a response of substance to the concerns that Mr. Wessels had raised in his email concerning, for example, the impact on DVS's core business being taken away?
No, I'm not aware.
And that was one of the concerns that you had raised, that then went to Mr. Stein, that then went to Mr. Wessels, and Mr. Wessels then was conveying it by way of his email below the one that we just looked at.
That's correct.
Right.
Do you know whether the reference to chairman in that email is a reference to the chairman of the Denel board?
It is indeed.
Corporate?
It is indeed.
Oh, and at that time, who was that?
Mr. Mantla?
Mr.
Mancha? Yes.
Okay, all right.
So this is not a reference to the chairperson of the DVS board.
No.
It's a chairperson of the Denel SOC Limited Board, SOC Limited Board, to whom Mr. Nsepe reported as Group CEO. Was that your understanding?
That's correct.
You must just think it through carefully, because there are boards for different entities, and then there is the overall board for Denel.
SOC.
Yes.
SOC.
So this was talking to the Denel SOC board.
And the chairman of that board.
The chairman of that board.
Okay.
What I understand from this email was, what happened was that Mr. Nsepe indicated that the chairman said DVS must be divisionalized, meaning we can't be a standalone business anymore. We must be pulled into Denel Group and not be a standalone company anymore, and that real cost savings must be shown, which I read between the lines as a subtle threat. In if we need to show cost savings, you've got two businesses. The work is there, but the only thing that's duplicated is the executive teams. So some of the executives need to go. That's the real cost saving. He also then goes further when he said, and Stefan will take the lead on this, which in effect will then mean that Mr. Stein's authority level is taken away from him and he is moving underneath Mr. Stefan Berger from DLS.
Right, thank you. May I then proceed to page 193? That's an email. You look at the table, including subject and who it comes from and to whom. It's an email sent on the 20th of November from Johannes Stein. Is that correct?
That's correct.
It's addressed to Mr. Mshluwana, Mr. Kruger, Mr. Duplessis, yourself, Ms. Geldenhuis, and Mr. Ndaba, and copied in Stephen Makabolo.
That's correct.
And what Mr. Stein says is this, all, since Zwelaki's surprising instruction given to me a few weeks ago to enter into an agreement with VRL, we've made good progress. Now, did you understand Zwelaki to mean Mr. Nsepe, and did you understand the instruction to mean that you must proceed with the single source supply agreement with VRL?
That's correct.
Did he explain to you why, or did you understand why that instruction came as a surprise to Mr. Stein? Was it the point that you raised earlier?
Because it wasn't driven by our business.
Yes. And then he continues, we've made good progress with Jan Vessel's help and oversight. We had several discussions with VRL and DCO about this. DCO meaning?
Denel Corporate Office.
Corporate Office, that's head office.
Yes,
Headed by Mr. Vessel's, reporting to Mr. Nsepe.
that's correct.
Right. The process evolved mainly around OMC. What is that?
So it stands for Oliphant Manufacturing Company. It's an old legacy name of one of the divisions of DVS.
I see. So mainly around that division's fabrication capability, how we protect it, not to increase risk in the business, and how we utilize it in the future. And then he says here, I had a brief review of revision 3 attached to the draft agreement with Jan Wessels and Stefan Berger yesterday at DCO, and both were happy with it. Since Zwelaki instructed Stefan to take the lead in the see below email from him, he, Stefan, will now discuss and finalize this agreement with VRL. Now, Stefan Berger was the CEO of DLS.
That's correct.
At that stage.
That's correct.
But the DLS already had its own single source supply agreement with VR Laser.
That's correct.
Is that correct? You were a separate, in fact, not only not a separate division, in fact, a separate company from DLS, which was a division of Denel itself.
That's correct.
Is that correct? Do you have any comment or feeling about why suddenly now Mr. Stefan Berger from a separate entity is now becoming actively involved in negotiating and finalizing the agreement with VR Laser?
Mr. Stein was resisting too much, and his executive team.
Right.
And like I said earlier on, in effect, him and his executive team was moved one layer lower than the authority then that sits with DLS.
Okay, thank you. And then it continues, I will keep you posted if and when I get feedback. Am I right to read, or do you also read into this a measure of unhappiness on the part of Mr. Stein that he wasn't necessarily being kept in the loop?
Yeah, I definitely read it that he will not be part of discussions because he is resisting too much.
Did he express that to you, Mr. Stein?
I cannot recall if
You
in
can't
so
recall.
many words, but
Okay.
we all knew this is what's happening.
And then my understanding is that Denel board approval is required before DCO can enter into this agreement. See Jan's email below. We, that's Jan, Odwa, and I, discussed and agreed this with Zwelaki last week. So until then, and after the agreement is signed, until after the agreement is signed, in other words, no onward communication, please. What did you understand that to be instructing you to do?
So we have to wait for the board approval, and let's first see if there's approval before we communicate within the business to the people in the business that there's an agreement being entered into.
And then his next paragraph reads, I pointed out to Jan and Stefan yesterday that we are making progress with determining the effect of this agreement on the DVS business and that it will be completed soon. And in the final paragraph, I won't read out, that seems to refer to his colleagues and superiors having to assist in relation to some of the financial data.
That's correct.
Okay, thank you. I'm sorry, Chairman, I just find the reference.
Okay.
Yes, I just need you to confirm, there's a draft agreement at page 196. In fact, sorry, not a draft, this is a signed agreement.
That's correct.
Were you involved in the drafting of this agreement?
No, this is the agreement between VR Laser and DLS.
DLS? Oh,
Yes.
so that was the one that was actually concluded, it seems at page 219 and 220 on the 18th or 14th and then the 18th of December 2015. Is that correct?
Just repeat again,
The
please.
signature was in December, page 219. Signatures happened on the 14th
Yes.
and 18th of December.
That's
But
correct.
that, as you point out, was the agreement between DLS
No.
as this.
The one agreement starts on page 209.
I'm sorry, I beg your pardon. Thank you very much. I do beg your pardon, Chair. It's actually at page 203 is what I was looking for. Thank you very much. It's the 19th of May 2015. Is that correct?
Yeah, so I was not part of this agreement. So
Yes.
this agreement starts on page 196, which is with VR Laser and the
Right.
DLS. And I wasn't privy to this agreement. I was given this agreement afterwards.
But you were told to use that,
Yes.
as it were, to copy
Yes.
and paste to do a similar agreement for
to use it as a
DVS.
basis. Yes,
And then the DVS agreement is from page 209.
that's correct.
Right. And now, apart from the initial drafting that you were involved in, were you involved in the finalization of the drafting of this agreement?
Yes, I was.
Right. And was that according to instructions from anybody?
Yes, so we were then told to complete the agreement. It was then given to DLS, and some of the senior people at DLS reviewed the agreement as well, and when they said they are happy with the agreement, we then concluded that we are in a position for Johan Steyn to sign the agreement.
All right. And did he in fact do that?
I believe, if I recall correctly, that VR Laser signed it first.
All right. Let's just take a look at 219.
Yes,
That was the reference that I confused myself with earlier. That was the 14th of December,
that's correct.
signed by Mr. van der Merwe. I see there's a witness who has signed there. Geldenhuis, is that yourself?
That is, but I was not present at the signature.
I see. And then on the following page 220, it was signed in Pretoria on the 18th of December by Mr. Steyn.
That's correct.
Is that your signature again as a witness?
Yes, and I was present, yeah.
You were present this time?
Yes.
How did it come about that you signed as a
I
witness
can't
to something?
recall, I was now shocked when I saw this. I don't know whether I've signed on the wrong line, I don't know.
And was this a binding one?
This is a binding agreement, yes. But not a binding witness.
And does this in fact mirror in substance the earlier agreement between DLS and VRL? In the sense that there was a commitment by the Denel entity to appoint VR Laser, obviously for different things, to do, but it was on a single source supply basis.
That's correct.
And what was the period?
It was for a period of 10 years.
Yes. Similar to the DLS agreement, which was also for a period of 10 years?
That's correct.
Right. Did you, and in fact, yes, did you have any view on that specific point? Leave aside the issue of whether it was a good business decision to give away a lot of DVS's core business to an outsider. Did you have any view as to whether it was appropriate to enter into an agreement for 10 years?
I cannot say that we've given this a lot of thought. At this stage, we were so, we tried everything not
Did
to
you feel
enter into this
defeated?
agreement. We had a couple of sentences that could give us out, but we stopped the fight. We couldn't proceed with it anymore. I mean, it ended up that, like I said earlier on, that the business was sort of restructured because we were resisting too much. So I cannot tell you that at that stage I even thought about the duration of the agreement. Because this is the agreement we're going to enter into. We will enter into it, and we have given ourselves a caveat in certain circumstances. We will not proceed with this agreement, and let's fight the fight when we get there, when we were supposed to place orders on VR laser.
But this agreement, was it signed after you had gone to the board, at Denel SOC board? Because I had earlier on the idea that, well, you would have to go and tell the board and see what it says. Had that happened by the time this agreement was signed?
I do not know if it happened. In the evidence, it is that Mr. Steyn asked Mr. Ntsepe if it indeed happened, if the board gave authority for us to proceed with the agreement. And then in my back there is an email back from Mr. Ntsepe that said, this is approved, go ahead to sign the agreement. So whether it happened in front of the board, whether the board ever discussed it, we bear no knowledge.
In terms of the emails exchanged, it's not clear whether when Mr. Ntsepe said this is approved, he meant that that had been approved by the board, or whether he meant as acting Group CEO, he was approving it.
No, I
You can't
just
remember.
want to look at the emails again. The email trail specifically referred to, there's a board meeting,
Yeah.
there's need to go to the board meeting, what happened,
Yeah.
what happened now. So if it wasn't said physically, did the board approve it? It's definitely alluding to,
Right.
did the board
Yeah.
approve this?
Oh, okay, all right. Mr. Kennedy?
Yes, thank you, Chair. May I just have a moment? I've just been drawn, my attention's just been drawn. You talking about? If I can just pick up a point that's just been drawn to my attention. If we can go back for a moment to page 190.
Maybe you are able to assist me in terms of the question I was asking.
Exactly, Chair.
Yeah.
I am, and I hope to be able to
Okay,
assist the
all
Chair.
right, okay.
But just before I get to the emails that Ms. Geldenhuis has just referred us to, that we will get to, may I just ask to go back to page 194, that very brief email that came from Mr. Ntsepe. Mr. Ntsepe said, page 194, remember the email that said, "Hi Jan, your email is too long." And as usual, he refers to a letter coming from the chairman instructing to divisionalize. That, of course, was not an instruction from the board, it seems, to specifically approve the VR laser contract. Correct?
That's correct.
Okay. But now if I can take you ahead to page 207. you'll see this is a trail of emails. I'd like to start on
Yes.
at the foot of the page. The one from Mr. Steyn on the 15th of December to Mr. Nsepe, copying in Mr. Wessels and Mr. Mshluana. Do you have it?
Yes, this is the emails I referred to earlier on to the chair.
Okay. Then what he says is, I think it's worth reading into the record, Chair. Zwelakhe, following your instructions a few weeks ago to sign an agreement with VR Laser for DVS's fabrication work, we had several discussions with them, initially with Jan involved and recently with Stefan Berger. VRL have now signed the agreement attached with minor adjustments after DLS, Stefan and Denise have reviewed it as well. DVS's legal, Carene, that's yourself, is it?
That's correct.
Also checked it from a legal point of view. Now, if I can just stop at that point, just to get some clarification. His email, we note, is dated the 15th of December, and we've noted a moment ago that VR Lays, in fact, signed it on the 14th of December. So he seems to be referring to the very agreement we looked at a moment ago to say to Mr. Nchepe, VR Laser have already signed it.
That's correct.
With a few minor amendments. And then to continue, he says, I'm not sure about the delegated authority in a case like this. My information is that it needs board approval, or you might want Fortune to review it, but I'm not sure. So Wessels expresses ignorance about whether the board approval is actually required, although he says he's told it seems to be required. Who is the Fortune, the person referred to as Fortune there?
Fortune was the legal manager at Denel Corporate Office.
Corporate.
I unfortunately can't remember or recall her surname.
Okay. And then I'm looking forward to your further instructions. So he's updated Mr. Nchepe to say the agreement has now been signed by the other side, that there has been checking done by people like yourself to check that it's legally okay. And then he refers, but he flags the issue of whether, in terms of the delegation, board approval is required. And then the email immediately above it comes from Mr. Nsepe back to Mr. Addressed this time to Mr. Steyn, copying in Mr. Wessels and Mr. Mshluana. Hi, Johan. It's approved. You can go ahead. So that one-liner says that it has been approved. Are you aware whether it had been approved at this or any other stage by anyone other than Mr. Nsepe himself?
No, but I understood this to be there was a board meeting and it's approved at the board.
Yes.
The tone throughout the correspondence was it needs to go to the board on the 7th of December. It needs to go to the board of the 7th of December. And this email is after the 7th of December.
Yeah.
So whether the 7th of December's board meeting took place, whether this was an agenda item on the board meeting, I bear no knowledge.
See, what stands out here is that he doesn't answer the question raised by Johan to say who has the authority to approve this, and because he says he thinks it's the board, but he says he's not sure. So Mr. Ntsebe doesn't say, yes, it is the board and the board has approved. He says it's approved, you can go ahead. He gives himself room later to say, I didn't mean it had been approved by the board because it didn't need the board approval according to me. It needed my approval and I granted the approval. Or if the board had approved, he might say, well, the board had approved and I was telling him he mustn't worry about that thing. It's been approved by the board. Just that I didn't say so expressly. But the answer is not categorical. Of course, the other emails that you refer to, which you were saying the board is going to have a meeting and so on and so on. It may well be that when one looks at that whole email trail, then one might give his answer as a certain meaning. Okay.
Thank you, Chair. Now, I just want to...
I'm sorry, we are at 5.
Yes.
How does it look like in terms of how much time do we need?
I hope about 30 minutes, Chair.
You think we'll finish at past?
I hope so, yes. I
Okay.
think that's probable.
Okay, all right. Maybe let's take a short adjournment, maybe 5 minutes,
Thank you, Chair.
10 minutes, maybe let's say 10 minutes because 5 minutes is going to finish while you are walking up if you are going
Yes.
out. Okay, let's take a 10 minutes break and then we'll come back.
Thank you, Chair.
We adjourn.
Very well, Carene. Thank you so much.
Okay, let's continue.
Thank you, Chair.
So by the time of the agreement that we're talking about now, the binding one, had the instruction to divisionalize DVS been carried out or not?
It never actually came to fruition. So we
Oh.
were working towards it, but it didn't come to fruition.
Were you working towards it in the same way you were working towards a non-binding agreement?
We were leading the non-binding agreement. Somebody else was leading the working towards divisionalizing.
Oh, okay. Yes, Mr. Kenneth.
Thank you, Chair. Could we turn to page 159 of your affidavit? You deal there in paragraph 6 to the next few pages with an item that you've headed, the outsourcing of the 40 outstanding N35 hulls to VR Laser and the termination of the Memorandum of Agreement. Now, is that the termination of the Memorandum of Agreement we've just been looking at that was concluded in December 2015?
That's correct.
Right. Now, can you just, I don't propose, Chair, unless you guide me otherwise, to go into the detail of this. The affidavit is there for the Chair to
Yeah,
read.
no, you don't need to.
Thank you, Chair.
Yeah.
Can you just sum up for us, before we get to the actual termination of the agreement, what did these 40 outstanding N35 hulls and their outsourcing to VR Laser Service, what did they involve? Were they hulls covered by the agreement that was concluded, the single source supply, or was this something separate?
They would have been covered by the agreement, but there was more than this 40 hulls, if I recall correctly, and now I might be wrong on the amount of numbers. We designed this vehicle and then we built 30 pre-production units. Now, part of you recall that we said that there is pilot runs that needs to happen before you can outsource your fabrication so that you get to a certain maturity level. We did build the vehicles in-house to get to the maturity level. Then there was a follow-on order it was part of the same order, but there was 40 vehicles to be built, which was now in a state that it is ready to be outsourced, and it is now past the certain maturity state. But then we decided that this 40 vehicles, and we kicked the ball from 2015 to February 2017, so now we are in February 2017, and we did our sums and we said it is not worth our while to outsource this. We need to build these 40 vehicles within DVS, and then Mr. Steyn informed Mr. Ntepe and Mr. Nwana that we're going to build, the executive team and himself decided we're going to build these vehicles within DVS.
Right. And that took place in 2017.
That's correct.
So you were not a very confrontational lot, but you knew what you were trying to do.
That's correct.
And then you refer, if I can take you perhaps to page 231, 230. 230. 230, yes. At the foot of page 230 is an email from Pieter van der Merwe, who was from VR Laser, is that correct?
That's correct.
And he was addressing your Mr. Steyn and yourself, Ms. Geldenhuis and others. What was this email relating to? What was he requiring?
So,
Was this relating to these additional items to be fabricated?
I am not 100% sure if it was only to that specific order, but it is indeed to all the work that has happened in DVS. So what happened was, in the binding agreement, we kept that caveat for ourselves: if it makes financial sense for us, we will look at it to contract VR Laser. But what we kept on doing is we did our business case the case each and every time before we placed the order. And what we did is we did ask VR Laser to quote, and we did ask other people to quote as well. And then based on information that we got, we figured out what it is that we can do ourselves, and then we decided. So this email that was written in July 2017 by Mr. Pieter van der Merwe, and I have to just qualify that I wasn't deeply involved in the supply chain process and the various programs and opportunities that was running at that stage, which he's referring to. He came to us and he said, but we've entered into agreement. We are seeing in the market that we are quoting. You're never coming back to us and saying whether we are successful. We thought we've got a single source supplier agreement with you, but we don't see orders coming to us. Do you still think that we've got a single source supplier agreement, or don't you honor that agreement anymore? Which is in effect his email.
Which is then?
Which is in effect is the contents of his email.
Yes.
We've got an agreement, but we don't get work from you, so what is happening?
That is VR Laser.
VR Laser, yes.
And by the time of this email, you recall how long the agreement had been in place, or how long it had been in place?
Since December 2015.
So this was about a year and a half.
I can bring it under the Chairperson's attention that there was indeed one order that we did place on VR Laser for fabrication of hulls in this period. But our business case at that stage, where we were in our business, it would have been more to the business's profitability if we outsourced it, because we didn't have enough people at that moment. We had to ramp up and everything, and it made sense. At that stage, VR Laser was cheaper than us, than what we could have done it inside.
Okay.
So it made financial sense to us. I think, if I can recall correctly, it was for 9 RG32 vehicles that we placed the order on them.
All right, then if I may take you to page 232 and 3. These are two letters that you sent. The one, 232, is dated 8 March 2018, addressed to VR Laser CEO, and that refers to a termination that relates to Denel invoking the second paragraph. We have no alternative as to herewith invoke DVS's termination for convenience right that forms part of the terms and conditions on which the specific orders were placed on yourselves. The aforementioned orders is thus herewith cancelled. So you here cancelling particular orders?
That's correct.
This doesn't say you're cancelling a complete agreement, though.
No,
Right.
it was the orders.
And does the same apply to the subsequent letter of 3 April, page 233?
The subsequent letter is actually, the order number was incorrectly, so the subsequent letter was just fixing the incorrect quoted order number.
I see. So it was really just clarifying something from your previous letter.
Yes.
Again, not a termination of the agreement itself.
No,
Okay.
I understood that the strategic agreements with VR Laser, according to my knowledge, was cancelled at a corporate level at a certain stage.
Were you involved in that?
No.
Now, I just want to go back to a comment that you made earlier that Mr. Steyn was expressing, perhaps in diplomatic terms, in the emails that we looked at earlier, to a feeling that he was being sidelined or kept out of the loop, and Mr. Burger was now taking the lead in dealing with VR Laser, etc. Your own position as a member of the executive team at DVS, was there a change in what you understood to be the attitude of others in the Denel organization in relation to how you were being treated? In particular, when one looks at how Mr. Burger was now taking the initiative, Mr. Steyn was no longer kept in the loop to the same extent. Did this affect you also as an executive team in relation to these matters?
Yes. During the divisionalizing discussions, there was a new structure for the landwood business. Like I explained, show cost savings. There's just 2 executive teams. One needs to end up. And there was discussions with various executive members as to where you will fit in, who you will report to. And so we had to compete for our positions again.
But I'm
to
sorry,
be in this new landward structure on the executive team.
but I may have missed something. I understood the idea of restructuring and maybe Mr. Berger taking over and the DVS CEO being under him if DVS was divisionalized, as you put it. But if DVS was not divisionalized and remained a legal entity on its own, I don't see how that talk would fit in unless the talk may have been meant to intimidate the DVS executive or soften them up because they were being difficult. In other words, to kind of threaten them, if you continue this is what may happen. You better behave.
From a legal point of view, I agree with you. The structure can't work like that. It is 2 separate legal entities, and you can't now just dissolve a legal entity by a piece of paper overnight. Somebody that's not your employer now decide that we know, and that we've myself particularly raised numerous times to Mr. Berger and saying, but this cannot happen this way. And it was ignored. So whether it's a combination of a bit of threats going on or whether there was in my mind as a legal person, legally that could not happen. It just cannot happen. They don't have legal stance. But from a business perspective, from divisionalizing and consolidating, and Mr. Berger being the head of our business, in terms of the Denel Group, that happened, and he's got authority over us.
So you had a de facto restructuring,
Yes,
but not a de jure restructuring.
that's correct.
But from a certain point, you at DVS and the executives knew that from now on, we are under Mr. Berger or whatever.
Yes, from
Yeah.
that email where Mr. Nsepe said, and Mr. Berger will lead from now on.
Oh.
So there was a
yes.
meeting. He referred in that email. I showed an email to everybody from the chair when he said, and Stefan will lead.
Yes.
From
yes.
that moment.
So it was from that moment.
From that moment, yes.
Sure. Yeah. Yes, Mr. Kennedy?
Thank you, Chair. Ms. Geldenhuis, I just want to take you through a couple of the final paragraphs in your affidavit. Some of those we've touched on already, so I don't propose to go into those. In paragraph 9, you refer to the prescribed procedure in identifying a single source supplier. When did your company move into the Denel Group? At what stage was that? How soon before this agreement took place?
So it was, if I recall, 28 April, the transaction closed.
Which year?
2015. So
2015,
it's 5,
yes.
6 months prior.
6 months prior.
Yes.
You indicate your lack of knowledge of particular processes within the Denel Group at the time. Just explain that to the chair,
So
please.
when we obviously, from the regulatory framework for a state-owned entity is vastly different from what it is for a private company. And we understood and we were informed that for the first year, while we are part of the Denel stable, we will not be subject to the PMFA. So we updated our processes. We started with integration and everything whilst we are doing our day-to-day work. But there was no real knowledge for us during that period of exactly the PMFA and what is required from us, because the integration wasn't completed. And we didn't know that, or we were told that the PMFA was not applicable to us.
Now, may I just go back to one point that my learned colleague has drawn to my attention, which I think does indeed need reference. Just go back to page 185. Yes, this is the email we looked at earlier, 13th of November, from Mr. Steyn to inter alia yourself. The third line after greeting Piet, Carene and Percy, he says, following Zwelaki's request 2 weeks ago to finalize a formal agreement with VRL for the fabrication of our hulls in future. Several interactions took place. Sorry, may I just have a moment? For the finalization of our hulls in future, several interactions took place between DVS and VRL to start the process, and this is the important part, to evaluate VRL's capability. Now, that must be seen against your evidence earlier that DVS had its own in-house capability and one division in particular might be heavily hit. So Mr. Steyn refers to a discussion about a process which would involve, amongst other things, evaluating VRL's capability. In other words, to ensure that if VRL was going to get business that DVS was already doing in-house, it would have to at least be sure that VRL could do the work. Now, if I can take you to page 211. This is part of the agreement that was actually signed in December 2015 that you witnessed. And at page 211, in clause B, B is part of clause A, which deals with the scope of the Memorandum of Agreement. It reads, VRL, with its proven capabilities and quality, is considered to be a key supplier and a strategic partner to DVS. Now, so Mr. Steyn's email sometime before said we need to evaluate VR Laser's capabilities. The agreement then says, well, it's already proven that it's got remarkably good capabilities. You've already given evidence that VR Laser had already been for some time a supplier to Denel. But are you aware of what steps, if any, were taken, in fact, to carry out Mr. Steyn's feeling that before such an agreement is concluded, VRL's capability, specifically in relation to this type of work that you could do in-house, whether that was actually tested and established?
I know that Mr. Steyn requested Mr. Kruger and Mr. Ndaba to visit VR Laser to go and sort of do an inspection or to go and see what their capabilities is and what is happening there. And I know that was, if I recall correctly, that was also met a couple of days later from Mr. Nsepe to Mr. Steyn in a very unfavorable tone, when he said that your people are jeopardizing Denel's business going to VR Laser. So that's what I recall that happened. I do think
Who said your people are jeopardizing Denel's business going to VR Laser?
It was Mr. Ntsepe that said that to Mr. Steyn.
Saying, in other words, saying they shouldn't be going
Yes.
there. It's quite a telling remark. Yes, okay.
I also think that the reference to capability that Mr. Steyn made in his email that you referred to is also referring to maybe there is additional work that we can send to VR Laser that would not be the whole fabrication. So go and see what it is that they can do. Maybe we can send them other work and not our core business.
But ultimately, they in fact concluded a single source supply
Yes.
agreement for all the
Yes,
work. Yes.
but the wording in this single source agreement was we gave up.
Yes.
We gave up.
Chair, may I conclude with just one more very brief topic? On page 163, you deal with the legal status of the Memorandum of Agreement, and you refer to certain litigation that was initiated, brought by VR Laser against DVS. Were you still the legal executive at DVS at the time that was started?
Yes, I was.
And just very broadly, what does the litigation relate to? What is VR Laser asking the court to do against Denel Vehicle Services?
So I referred earlier on that there was indeed an order that was placed on VR Laser that made sense to us, and we received goods from them. We never paid them. When there was a combination of activities between Denel ran into financial difficulties, we got a new board, allegations of state capture with VR Laser. It was, you are not paying. Let's first look at what happened here, and let's see if the agreement is tainted and how we're going to deal with it further. And now I don't want to testify anything further because then I will,
Yeah, no.
it's
We
sub
understand.
judice.
Yes,
Yeah.
I
certainly.
can't testify
We
further
understand, yeah.
Right.
on this point.
Thank you. And then in 1134, on page 164, you refer to an intention by DVS to review and set aside the Memorandum of Agreement. Notwithstanding that, it paid an amount of 2.7 million to VR Laser.
That's correct.
Had that been started, that review application, before you left office as legal executive of DVS?
If I recall correctly, the review application hasn't started. What happened in these circumstances, the LS owed VR Laser a lot of money as well. Because DV or Denel was in financial difficulties, there was a lot of work that was with VR Laser that the moment that it's released, DLS could get money, could make a sale, and they could get money in for the business. So the payment from DVS of half of 2.7 million rand was sort of to secure that VR Laser release some of DLS's goods that was work in progress so that DLS can sell it so that they can generate more cash. So
Thank you,
it was a group type of arrangement to get more liquidity into the business at that stage.
Right. Thank you. Thank you, Ms. Geldenhuis. Chair, we have no further questions from the legal team.
Thank you. Thank you very much, Ms. Geldenhuis, for coming to assist the Commission. We appreciate it very much. If we need you to come back, we'll ask you to come back, but thank you very much. You are now excused.
Thank you.
Thank you. Mr. Kennedy, tomorrow, your estimate of how much time we need for your witness is what?
My estimate is still probably 3 hours, Chair.
Yes.
So I hope that we can
can
finish
start at
comfortably.
Should we start at 9?
I believe so. That
Yes,
would
if we
assist.
want
Thank
to
you,
finish
Chair.
at 12.
Yes, thank you, Chair.
Yeah.
That should be feasible.
Yeah.
As I've indicated to you previously, we plan to call only the one witness, Mr. Turbers. He will in fact cover quite a lot of material, but we think that we can finish it comfortably within 3 hours.
Yes.
May I just draw to your attention one logistical thing? You have previously been given a bundle of his documents, his affidavit and annexes. We've been given at a late stage a supplementary affidavit. I've in fact not yet had a chance to work on it. I will tonight. But may I just indicate to you that you should expect a supplementary affidavit coming tonight, which I
Okay.
understand will be sent
Yeah.
via your registrar.
Yeah. Okay,
Chair.
no, that's
Thank you very
fine.
much.
That's fine. So tomorrow we'll start at 9 then.
Thank you, Chair.
Yes. We'll adjourn for the day, and tomorrow we start at 9. We adjourn.